Order, order, order. Would everyone ensure that all electronic devices are turned off or switched to silent mode? Tea and coffee, as people know, are not allowed in the committee room. We now continue line-by-line consideration of the terminally ill adults end-of-life bill. I remind members, as I often do, that interventions should be short and raise points of clarification or questions. They should not be speeches in and of themselves. And members who do wish to give a speech should bob and to continue to do so throughout the debate in which they wish to take part until they are called. When members say you, we are referring to the chair. You should not be used to refer to each other. The debate should be through the chair. We continue the debate on Amendment 480 to Clause 23 in the name of Danny Kruger. Danny Kruger.
Thank you very much, Mr. Dowd. I'm just concluding my remarks, pushing the amendment in my name, and I was just making the point, which I'll finish making quickly, in response, I think, to a suggestion by the Honourable Lady and others, that it would be improper to deny people living in a care home or hospice setting or any other sort of collective communal environment the opportunity, the right to request assisted dying. And I was suggesting that that right needs to be tempered by an acknowledgement that they don't live there alone, and that there are also rights properly held by the occupier of the premises and by the individual's neighbours and others. So my concern is that just as we know that suicide itself is contagious, there are social ramifications when assisted suicide is practised. And while we fully recognise that if this law were to be passed, people would have the absolute right to request the service in their own home, I think in the case of when they're living among others, that right would need to be tempered by the consideration that the occupier should ultimately decide whether he or she is prepared to allow the practice to take place in their premises. Just a quick other point that occurred to me during the debate, Mr. Chair, is my concern suggested by some members that it would be appropriate if a institution were receiving public funding, that they should be obligated to deliver the service if it is indeed legal. And I am very concerned about the implication there that we might arrive at a place where an institution which did not wish either to provide or to facilitate assisted suicide, but did receive public money, for instance a care home or hospice, would be at risk of losing that money and essentially being defunded on the grounds of their conscientious objection to participating in assisted dying. And I'd be grateful for any clarification we can get from the sponsor or the ministers to confirm that it is not the intention of the bill or the government to penalise bodies that do not deliver assisted dying by any kind of withdrawal of public money. And just to conclude with the point about the impact on staff, as I've said, I think it is important, and I'm grateful to the Honourable Lady for acknowledging that we need to tighten the bill to ensure that it's clear that people will not be required to participate in any stage of the process of assisted dying, not just the actual provision of assistance towards the final act. Nevertheless, my concern is on behalf of staff that if we do not give institutions where they work the right to opt out from provision, we will see an exodus of staff who do object to being involved in any way or working for an institution that facilitates assisted dying, as has happened in other jurisdictions where assisted suicide is legal. And I point particularly to evidence we heard from Australia, where we were told that in consequence of assisted dying being legalised in Australian states, there was an exodus of workers in the healthcare system there, nurses and others, and in their social care system. And it was therefore no coincidence for one of the Australian witnesses who supports assisted suicide to declare breezily that when the law was first debated, there had been significant objections in the care workforce to the introduction of assisted dying. 5 years later, there was overwhelming support for assisted dying among the care workforce. Well, that is no surprise, because all the objectors had left. And I'm afraid that's what we will see here. And a comparison would be the exodus of care workers that we saw after the last government mandated COVID vaccination. 40,000 care workers left their jobs rather than accept compulsory vaccination. And if they're prepared to do that on those grounds, I fear we might see a similar phenomenon take place if we were to mandate that workers must be compelled to work in institutions, that we would mandate that institutions must be required to facilitate assisted dying. Happy to give way.
Is that concern?
I thank him for giving way. And can I just check that his understanding is the same as mine, that there is nothing in this bill that compels an organisation to participate in the way that he outlines?
Any Kruger?
Well, I'm grateful, but no, I'm afraid I don't concede that. At the moment, it is not apparent from the bill, or from the amendments that have been accepted, that an organisation would be enabled to decline to facilitate the provision of assisted dying. No organisation will be compelled to do so, but if a resident were to request assisted dying in their care home, at the moment, my understanding is the care home would be obliged to facilitate it. And it might well not be the intention of the movers of the bill, because I recognise very much that the Honourable Lady and members who agree with her recognise the importance of a conscience exception, absolutely. And they've been very, very clear on that, and I'm grateful to them. Nevertheless, my concern is, and we've heard in fact from the Minister on human rights grounds, that the likelihood is that there would be a claim on behalf of an applicant against the institution that they reside in, that assisted suicide must be provided to them in that place. So I'm afraid the bill at the moment doesn't give an adequate exception to institutions. I'll come back to the Honourable Gentleman and then to my Honourable friend.
I thank him. Would he accept the distinction, though, that I made in terms of an organisation choosing to provide assisted dying services versus the instance that he outlined on the care home of that being done in someone's home that happens to be in a care home? They're entirely different points. And I fear that, particularly with regard to hospices, he is conflating the two.
Annie Kruger?
I'm grateful. I'm conflating the two because they are conflated in reality. A care home where somebody lives is a residence, but it is also a community, it's a facility. It's a place where professionals work to support that individual. And the suggestion that there is a clear demarcation between their living arrangements and the support that they receive from the institution they live in, it doesn't exist in reality. That's why they are living there, because that distinction does not apply in their particular case. They require the support and the help of the workers in the place that they live. So I'm afraid it's not enough simply to say this is their home and they should have exactly the same rights and freedoms as they have if they were living in their own home alone, in their own flat or house. I'm afraid we do have to recognise the reality of the situation, which is they're living in a community, and what happens in the community affects them all, and that is the nature of communal living. And this is because this is not individualised healthcare in the way that I think the Honourable Gentleman imagines it is, and that is fundamentally our point of difference. This is something that is outside or separate to or adjacent to healthcare, and it is delivered by definition by somebody else. And it, by virtue of this bill, would have a separate regulatory environment to other healthcare treatments. And of necessity, it should have a appropriate legal framework to protect other people who are impacted by assisted death in a communal setting. And that is, I suppose, my crucial point. If you're living in a communal setting, what you do affects your neighbours. Happy to give way.
I'm grateful to the Honourable Member giving way, but would he also appreciate that we also have, although this is different to the healthcare services that we currently have, we have a legal framework that deals with many of these conflicting issues as and when they arise in lots of different circumstances which are not completely adjacent to these.
Annie Kruger?
Well, I'm grateful. I don't know quite what those might be, but I'd be interested to hear. There might well indeed be the case. And I'm afraid there are no hard and fast rules that can be clearly applied here. Or rather, we have to apply a hard and fast rule in the knowledge that there are grey areas, there are exceptions, there are situations in which we might feel that the law is being unjust in particular cases, and we've heard from others examples and the evidence that the Honourable Lady cited of the lady in Australia, I can well imagine the distress that's involved if you suddenly find that you're in an institution that doesn't permit you to have an assisted death and you want one and you're in your last days. But the alternative is a different blanket rule. I mean, if we're going to have a blanket rule that you can do it anywhere, that's one situation. I think there'll be significant knock-on effects, serious moral injury suffered by other professionals and by other residents. I recognise that my amendments could potentially lead to somebody having to relocate if they want to have an assisted death, and I'm sorry for that. But I think we've got to draw the line in a way that makes most sense. So, just to conclude, let me give way to my own friend.
I'm grateful, and it'd be interesting if this amendment goes through to see a series of plebiscites taking place in care homes and communal situations across the country as to what the residents do and don't want, presumably by majority. He asserted that there'd been a mass exodus of healthcare workers in Australia when VAD came in, and I'm struggling to find any evidence to support that claim. In fact, the evidence seems to say that's not the case, although they have seen some resignations. That's largely been, as you would expect, because of paying conditions.
Danny Kruger.
I'm grateful to my right honourable friend, and on the first point, he seems hung up on this suggestion that there needs to be some sort of plebiscite or kind of communal decision-making, some kind of citizen's jury, which I'm not suggesting for one moment. In fact, I'm sure I've explicitly said what I would want, what the amendment would enable, is that the owner or the occupier, who's probably an individual or board of directors, would decide what happens. They might well, if they're a decent, compassionate organisation, consult with residents. In fact, I would very much expect that to happen if they're doing their job properly. But no, I'm talking about the importance of communal living. Nevertheless, a communal living arrangement has leadership, and the residents of it have signed terms and conditions. They've signed a contract under which they agree to abide by certain rules of the house. And my suggestion is if the charity, company, organisation that is managing a care home wants to stipulate that there shall be no provision of assisted dying in that care home, they should have the right to do so, which I would hope my right honourable friend would acknowledge is consistent with English property rights. To his second suggestion, that I'm grateful to him, he might well be right, and I'd be happy to consult my evidence pack, which I haven't got at my fingertips, about the effect on the Australian workforce in consequence of the introduction of assisted dying there. My memory is that we did hear evidence, or evidence was submitted to us in written form. His knowledge of the 500 submissions might be better than mine. Let's check, and we'll have it out, perhaps on social media. I know how much my honourable friend enjoys that forum. Right, is that enough?
Thank you. Amendment 480 to clause 23, as on the amendment paper. The question is that the amendment be made. As many as are of that opinion say aye. Aye. To the contrary, no. No. Division. Okay. Now lock the doors.
Jack Abbott. No. Lewis Atkinson.
No.
Bambos Charalambos.
No.
Daniel Francis.
No.
Tom Gordon.
No.
Rachel Hopkins.
No.
Sojourn Joseph.
No.
Stephen Kinnock.
No.
Danny Kruger.
Aye.
Kim Leadbeater.
No.
Kit Malthouse.
No.
Sarah Olney.
Aye.
Dr. Simon Oper.
No.
Rebecca Paul.
Aye.
Jake Richards.
No.
Sarah Sackman.
No.
Liz Havel Roberts.
No.
Naz Shaw.
Aye.
Dr. Neil Shastrihurst.
No.
Dr. Marie Tidwell.
No.
Sean Woodcock.
No.
The ayes were 4, the noes were 17, so the noes have it. The noes have it. Unlock. We now come to Amendment 483 to Clause 23, which has already been debated with Amendment 480. Does any member wish to move the amendment formally? No. We now come to Amendment 484 to Clause 23, which has already been debated, with Amendment 480. Does any member wish to move the amendment formally?
Like to move.
Amendment 484 to Clause 23, as on the amendment paper. The question is that the amendment be made. As many as are of that opinion say aye.
Aye.
Of the contrary, no. No. In that case, we'll have a division. Lock the doors. Thank you.
Jack Abbott.
No.
Lewis Atkinson.
No.
Bambles Lambos.
No.
Daniel Francis.
No.
Tom Gordon.
No.
Rachel Hopkins.
No.
Sir John Joseph.
No.
Stephen Kinnock.
No.
Danny Kruger.
Aye.
Kim Leadbeater.
No.
Kit Malthouse.
No.
Sarah Orney.
Aye.
Dr. Simon Ofer.
No.
Rebecca Paul.
Aye.
Jake Richards. Sarah Sackman.
No.
Liz Saville Roberts.
No.
Naz Shah.
Aye.
Dr. Neil Shastri Hurst.
No.
Dr. Marie Tidball.
No.
Sean Woodcock.
No.
Thank you. The ayes were 4, the noes were 17, so the noes have it, the noes have it unlocked. We now come to Amendment 441 to Clause 23, which has already been debated with Amendment 480. Does any member wish to move the amendment formally?
Move formally.
Amendment 441 to Clause 23, as on the amendment paper. The question is that the amendment be made. As many as are of that opinion say aye.
Aye.
On the contrary, no. No. Division. Lock the doors.
Jack Abbott.
No.
Lewis Atkinson.
No.
Bambles Lambos.
No.
Daniel Francis.
No.
Tom Gordon.
No.
Rachel Hopkins.
No.
Sir John Joseph.
No.
Stephen Kinnock.
No.
Danny Kruger.
Aye.
Kim Leadbeater.
No.
Kit Malthouse.
No.
Sarah Orney.
Aye.
Dr. Simon Ofer.
No.
Rebecca Paul.
Aye.
Jake Richards.
No.
Sarah Sackman.
No.
Liz Saville Roberts.
No.
Naz Shah.
Aye.
Dr. Neil Shastri Hurst.
No.
Dr. Marie Tidball.
No.
Sean Woodcock.
No.
The ayes were 4, the noes were 17, so the noes have it, the noes have it unlocked. We now come to Amendment 481 to Clause 23, which has already been debated with Amendment 480. Rebecca Paul, do you wish to move the amendment formally?
I beg to move.
Amendment 481 to Clause 23 as on the amendment paper. The question is that the amendment be made. As many as are of that opinion say aye.
Aye.
On the contrary, no.
No.
Division. Lock the doors.
Jack Abbott.
No.
Lewis Atkinson.
No.
Bambles Lambos.
No.
Daniel Francis.
No.
Tom Gordon. Rachel Hopkins.
No.
Sir John Joseph.
No.
Stephen Kinnock.
No.
Danny Kruger.
Aye.
Kim Leadbeater.
No.
Kit Malthouse.
No.
Sarah Orney.
Aye.
Dr. Simon Ofer.
No.
Rebecca Paul.
Aye.
Jake Richards.
No.
Sarah Sackman.
No.
Liz Saville Roberts.
No.
Naz Shah.
Aye.
Dr. Neil Shastri Hurst.
No.
Dr. Marie Tidball.
No.
Sean Woodcock.
No.
Thank you. The ayes were 4, the noes were 17, so the noes have it, the noes have it unlocked. We now come to the question that Clause 23, as amended, stand part. The question is that Clause 23 stand part of the bill. As many as of that opinion say aye. Aye. On the contrary, no. I think the ayes have it. The ayes have it. We are now coming to Clause 24, Amendments 504, 505 and Clause 24 stamp out. However, just a reminder to members that we expect votes at about 10 to 3, of which there'll be a number, 4 or 5 maybe. So similarly to last night, we'll take an hour at this stage. We'll come back in that case if we do suspend. We'll come back at, in effect, 10 to 4, but we'll cross that bridge when we get to it. So we now come to Amendment 504 to Clause 24 in the name of Kim Leadbeater, with which it would be convenient to consider Amendment 505 and Clause 24 stamp out. I call Kim Leadbeater to move. I call him back to move Amendment 504. Thank you.
Thank you very much, Chair. Chair, these amendments relate to the criminal liability under the Act, and they get to the heart of why this bill is needed. Amendment 504 seeks to clarify the language of Clause 24 and provide reassurance that it will not be considered an offence to perform a function under the provisions of this bill, nor to assist a person seeking to end their own life in connection with anything done under this bill. This amendment ensures that those acting within the law and with compassion, assisting terminally ill individuals who wish to end their suffering and take control at the end of their life, are protected under the law. Furthermore, Amendment 505 ensures that the provisions of the Terminally Ill Adults and End of Life Act supersede the Suicide Act 1961, providing clarity that actions taken under the new Act will not be subject to the outdated legal framework established under the 1961 Suicide Act. This is a crucial step in modernising our laws to reflect the values of compassion, dignity and personal autonomy. These amendments bring us closer to a legal framework that is clear and safe. Chair, our now Prime Minister, Sir Keir Starmer, former Director of Public Prosecutions, stated in relation to assisted dying, the law must reflect the changing moral landscape of society. And in cases such as this, where the individual's autonomy and suffering are at stake, our legal framework must offer clarity and compassion. Sir Keir also emphasised in his tenure as DPP the importance of not criminalising individuals who act out of compassion, particularly in difficult and morally complex situations. He said, the law must be clear, and it must ensure that those who act with the intention to relieve suffering are not penalised, as long as their actions are in accordance with the law. This sentiment is echoed in the amendments before us today. They ensure that those who assist individuals under the bill are protected by law, offering clarity and reassurance to both the public and professionals who may be involved in such decisions. Sir Max Hill, another former Director of Public Prosecutions, remarked in 2019, the law around assisted dying is often unclear and creates a great deal of uncertainty for both individuals and healthcare professionals. What we need is a system that balances compassion with protection, ensuring that people who are the most vulnerable are supported in a way that is both legal and ethical. Sir Max Hill's words emphasise the need for clear, compassionate guidance, which these amendments will provide. They will help eliminate the legal uncertainty that can cause fear and hesitation in those who act in the best interests of individuals facing terminal illness. The 2010 DPP policy clarified that assisting someone to end their life was not automatically criminal, and each case would be assessed on its individual facts. However, this hasn't changed the law, and many people are still being failed by the law as it stands. These amendments create clarity and prevent ambiguity around what constitutes a criminal act versus an action legally protected by the new law. And I'll finish, Chair, with a very powerful testimony from Louise Shackleton from Scarborough. Louise accompanied her husband to Dignitas last December. I believe she was the first person to make that trip since the second reading debate here in Parliament. Louise talks about the trip that she made with her husband to Switzerland, and she says, this is not an easy process, as some against assisted dying might have you believe, might try and convince you. It is a robust and thorough, almost an ordeal in itself. Then there is the cost, not just financially, but mentally and physically, as he had to be able to get to Zurich, and someone had to assist him to do this. My husband did not deserve this to be his end, nor did I deserve this to be his end, my last memory of him. I accompanied my husband to Switzerland, where we had 4 wonderful days together. My husband's mood had lifted. He was at peace. It was as if the weight of the world had been lifted from his shoulders. He was not scared, no anxiety. His emotional suffering had ceased. You cannot imagine unless you see and feel this. He was looking forward to a peaceful death, looking forward to leaving his pain and suffering. At the end, my husband was able to die on his own terms, pain-free and peaceful, held in my arms as his heart gently slowed and finally stopped, granting him the dignified and serene farewell that he had wished for. But where was I? Alone in a strange country. Alone, scared, bereft, organising an Uber to take me away from the Dignitas house. I was vulnerable and in utter shock, now having to leave my dead husband alone, leave his body to be cared for by people I had never met. Due to our draconian laws, my husband had to be in a foreign country, had to be cremated to be brought back home. No funeral that he would have chosen, no mourners, no ceremony, cremated with no reverence to pray for him, returned to me in a cardboard box. The pain is excruciating beyond any other loss I have experienced. I have now been arrested and spent just under 3 hours being interviewed by 2 CID officers. 4 days after my husband left my world, there I was, stuck in a police station, being cautioned, questioned, having to relive my trauma for my crime, a crime made by love, a crime made by adoration, a crime of compassion and respect of my husband's last wish. She now faces a prolonged police investigation. She tells us, my husband was the first British person to go to Dignitas after the parliamentary debate on Friday the 29th of November 2024. She says, you have the power. The power is yours to be human, to follow God's wish, to suffer choices that other people may make, even if it's uncomfortable for you. Palliative care, I hear you say. My husband did not want palliative care. Please give others the gift of dignity and a good death in their homes. You have the power to do something amazing. Give people the choice. I speak to those amendments, which will help many people, including, sadly it's too late for Louise, but many other families who will potentially go what she's been through. Thank you, Chair.
Thank you. Amendment 504 to clause 24 as on the amendment paper. The question is that the amendment be made. Danny Kruger, could people bob, please? Could people bob if they wish to speak?
Might I yield to my honourable
Yes,
friend?
Rebecca Paul.
Thank you, Chair. I wish to speak briefly to the clause stand part. So as I noted, it feels a long time ago now, but a few weeks back when we were debating Amendment 82, this clause leaves the law in a strange position, and I hope we now have the opportunity to explore that and make sure that we are comfortable with the position or identify if any changes are needed. So Section 2 of the Suicide Act criminalises both assisting and encouraging suicide. So it reads, a person commits an offence if D does an act capable of encouraging or assisting the suicide or attempted suicide of another person, and D's act was intended to encourage or assist suicide or an attempt at suicide. It is a single offence, but one which can be committed in those 2 ways, either through assistance or through encouragement. Subclause 3, both as currently in the bill and as amended by Amendment 505, makes an exception to the Suicide Act, but that exception from criminal liability is only for the assistance piece, not the encouragement piece. It covers the provision of assistance to a person to end their own life under this Act, or the performance of any other function under this Act, or assisting a person seeking to end their own life in accordance with that Act in connection with the doing of anything under that Act. In other words, it is strictly limited to assisting suicide. It only covers the actions in this bill around conducting the preliminary discussion, assessing the applicant, giving the applicant the approved substance, and so on. So what happens to the other half of Section 2 of the Suicide Act? What happens to the offence of encouraging suicide? I will not rehash the debates that we had over Amendment 82, but I will point out that as that amendment was rejected, the law now doesn't dovetail. It is still very much an offence under the Suicide Act, as it has not been accepted by this Act. And because my amendment wasn't made, we have the absurd situation where someone can commit that crime, actively encourage someone to take their own life, yet that's not looked for or taken into account in assessing someone's eligibility for an assisted death. And on the flip side, this actually puts in place a very real risk for families and friends of loved ones who could overstep the mark and move from support of a loved one to encouragement inadvertently. It doesn't take much imagination to realise this could lead to accusations and potentially even prosecutions if the law isn't sorted and clarified at this stage. So we already know how difficult it has been for family members wanting to accompany loved ones to Dignitas but fear they could face prosecution. And the Honourable Lady so eloquently made that point. No one wants to see that situation. So it's really important that we make sure this bill doesn't create a similar situation where someone could be unfairly prosecuted for encouragement, which is still very much a crime under the Suicide Act. So let's make the law really clear on this point, so that we know what behaviours are criminal and what aren't. One of the causes of the unclarity is the word encouragement itself. What is its meaning, and what type of activities would a court consider to be encouragement under the Suicide Act? Again, I know that we had some of this debate, we started this debate a number of weeks ago, but I look forward to the Minister clarifying this and setting out whether she is happy with the current bill as drafted. Under this clause, coercion and pressuring a person into an assisted death is a criminal offence, rightfully so. However, there's been much debate previously whether this also covers undue influence and indeed encouragement. On the former, the Minister previously advised that undue influence is covered by these terms, whereas on the latter, I seem to recall that it could be covered as well. But if that is correct, we would have the sloppy situation where encouragement could be a criminal offence both under this bill and the Suicide Act. Again, I think it would be really helpful for the Minister to set out the position clearly on this point, just to make sure we don't inadvertently end up with that situation. I would imagine best practice is such that we only want one criminal liability, if appropriate at all, in one act or the other. Thank you.
Andy Kruger.
Thank you, Mr. Dowd. Thank you. I'm very honoured to follow my honourable friend, and I very much agree with the points you made, and I hope ministers will respond to them. I'll try not to repeat her arguments. I agree with them very much. The Honourable Lady for Spen Valley, who moved the amendments, said in her speech just now that this clause is, in a sense, the heart of the bill. And I agree with her. Without this clause, the whole bill would be ineffective because the treatment, the service that we're proposing to legalise would be illegal. And we've heard many objections to the term assisted suicide, but this clause and its necessity does expose the fact that what is being legalised, at least in part, is assisted suicide, and therefore calling it assisted suicide is not improper. It is simply using the correct terminology, which I believe we should in this place. And this is particularly important because as the use of the euphemism assisted dying masks what this is really about, what this bill would actually legalise, that somebody could help somebody else to commit suicide. As a result of this euphemism, and it's no surprise that the euphemism is deployed, support for what is called assisted dying is in part driven by a failure to realise what it actually is, what the words mean. And I just cite a 2024 Nuffield Council of Bioethics survey of the public, which found that 39% of people think assisted dying means withdrawing life support. 19% think it means providing people who are dying with drugs that relieve symptom of pain or suffering. 13% think it means providing hospice care, all of which is legal, all of which is good medical practice currently. Now, happy to give way.
He states that he's clear that those actions are assisting suicide. So I just wonder that he thinks are illegal. I just wonder whether he then thinks that members of the public, like the instance that the Honourable Lady referred to, it's right that they're investigated by the police on return from trips to Switzerland, etc.
Well, I'm grateful. Let me come to the question of investigation by the police in due course. I'm not sure the Honourable Gentleman was hearing me clearly. I wasn't talking about offences that I think are rightly criminal. I'm talking about offences which are not offences at all. Activity which is currently legal, perfectly permitted, providing hospice care, helping people relieve symptoms of pain and suffering, withdrawing life support, all of which is currently legal, in our system, the issue is that a significant proportion of the public think that those activities are what assisted dying entails. So that was the point I'm making. But I recognise the point and the power of the testimony recited by the Honourable Lady. So let me come to that in due course. I understand that in order to make the bill effective, an exception to Section 2 of the Suicide Act must be made. Of course, Section 1 says that you are allowed to commit suicide. Section 2 says you're not allowed to help somebody else to do so. Given that, and of course I agree that is necessary if we're to pass this bill, I do not follow why Clause 24(1) is included, is why it's needed. And I would be grateful if the member for Spen Valley could, or the Minister, could explain which other offences would necessarily be committed by a doctor properly carrying out his or her functions under the Act. So, what other offences might be caught that need to be that require Section 24(1)? The bill forbids in Clause 18 a doctor from engaging in euthanasia. So, one criminal law for which it's not necessary to have an exemption from is the law of murder. Yet, ostensibly, subclause 1 has no such limitation. So I would be grateful for the Minister's confirmation that subclause 1 would not afford a defence when the charge is murder. I presume that's not the intention. Then what about manslaughter, and in particular gross negligence manslaughter? So suppose, for example, that a pharmacist performing the function of prescribing or dispensing the legal drugs under this Act, he would be, to use the wording of Amendment 504, performing a function of the Act. Supposing that pharmacist makes a grossly negligent mistake and mislabels the drug, they then get sent to another patient who takes them and dies. This would quite clearly be gross negligence manslaughter. And I'd be very grateful to the Minister for explaining why Clause 24(1), as amended by Amendment 504, would not benefit from an immunity from gross negligence manslaughter. So to be clear, I agree that if the pharmacist unintentionally mislabeled the drugs, he could not be described as performing any other function under this Act, and so he would not have the defence. But in a case where in good faith he thought he was, but he made a fatal mistake, grossly negligent mistake, surely he was performing such a function, albeit performing it very badly. So can the Minister clearly set out their reasoning for why there is no chance of this happening, of there being no defence under this clause? Of course the sponsor doesn't intend to exempt pharmacists acting in that grossly negligent way, to exempt them from criminal liability. I'm trying to make sense of the drafting of the amendment. And if there's any other particular criminal offence other than the Suicide Act, which requires an exemption, it would be best to say so clearly on the face of the bill, rather than relying on this catch-all term, as subclause 1 does. Now, points made by my honourable friend I concur with, and I won't repeat, but I do find it interesting that the sponsor has chosen to retain the offence of assisting and encouraging suicide. And this is because two arguments made by proponents of the bill lead to the logical conclusion that the offence should be either repealed entirely or limited to self-conduct, as in the case in Switzerland. And so let's take these two arguments of autonomy first. If an autonomous individual with capacity decides to end their own life and requests the assistance of another person, why should that other person be criminalised? After all, that person is simply helping another person to do something to their own body which the law no longer prohibits since 1961. So it's a violation of autonomy, surely, to criminalise such conduct of assisting in suicide. And Lord Mance, the former Justice of the Supreme Court, put the matter as follows during the second reading debate of the Meacher Bill in the other place. He said, suicide is decriminalised, yet assisting suicide remains criminal. Probably a unique exception to the principle that you can only be an accomplice to an act that is in itself criminal. So it's bizarre that we have being an accomplice to an act which is not criminal, but the accomplishing is. He goes on, if a person may choose freely to commit suicide, what justifies a refusal to allow them to obtain willing assistance? Now, of course, I do believe in the value of the prohibition on assistance. But the logic of the argument from autonomy, that you should be allowed to request assistance to help you to die, surely obviates the suggestion, the distinction that you shouldn't be allowed to ask somebody to help you to do so. So I don't see why we have kept Section 2 at all, and I'd be interested in hearing from the supporters of the bill what the limiting principle it is. Why do they think assisted suicide should remain a crime, despite it being a limitation of autonomy, outside the scheme created by this bill? Why are we simply creating a scheme within this bill? The second argument given, and I think it comes to the intervention from the Honourable Gentleman and the point made by the Honourable Lady, the current law requires people to travel to Switzerland anyway. So the argument against the current system comes in three different forms. One stresses the toll it places on families to know that they have committed a criminal offence, the people who assist, and could be investigated by the police, even though the chances of prosecution are remote. But I absolutely fully recognise, and I share all the concern of members about the terrible distress that must be faced by people who have in any way possibly assisted their loved one to take their own life. The second objection to the status quo makes the point about the unfairness the situation creates, and a colleague made the point at second reading, quote, "I do not want choice to be available only to those who can afford to pay. This is not just or equitable." So the suggestion that you have to pay to go to Switzerland is a sort of violation of equality. And the third is a constitutional argument. It is said that it is constitutionally improper for the Director of Public Prosecutions to have effectively decriminalised assisted suicide for people who travel to Switzerland. But the point I'm trying to make, Mr. Dowd, is that under this bill, anyone helping their relative travel to Switzerland or any other country would still be committing an offence under Section 2 of the Suicide Act. And research from My Death, My Decision, which is a campaign group pushing for a wider bill than the current one, which support this bill, but clearly they want it to go further. Their research found that 50% of cases going to Dignitas would not be eligible under this bill. And they help make my point, which is that I'm afraid the fact is the very moving testimony read out by the Honourable Lady we would still have stories like that if this bill were passed. And in fact, as my honourable friend said, there's, I think, a significant likelihood of more prosecutions. If this bill were to be enacted, the conclusion of the prosecutor, the CPS, might well be, and of the police. I certainly shall in a moment. I'll just give him a moment. The conclusion of the prosecutors might be that, given the existence of an assisted dying regime within the UK, assisting one's relative to go to Switzerland is more should be subject to a greater likelihood of prosecution. So I think that is a legitimate concern. Happy to give way.
Thank you for the honourable member for giving way. I think the point you're making is actually one that I made yesterday, and I appreciate we're on entirely different sides of this debate. But that was exactly why I was talking about making sure earlier on that we would have a wider eligibility, point he makes with My Decision, and also including making sure that there would be provision of assistance for people who might have illnesses like motor neuron disease. So does he accept that, we're in a situation where we have had to put a cut off somewhere along the lines, there are people outside there, but fundamentally it's about making sure that we do have safeguards, and I think that's the key point here, isn't it? That it is about the safeguards, and what he's talking about is exactly that.
Danny Kruger.
Well, I'm grateful, and with great respect to other members of the committee, I think he is the most honest advocate of assisted dying among us, because he genuinely recognises that autonomy demands the widest possible range of eligibility. And I recognise he himself also. It might be that other members feel that we've got the balance exactly right in this. I recognise the force of his argument that if we are going to introduce a new human right, then it is very difficult to circumscribe the boundaries for that. He himself does think there should be some boundaries, so 12 months was the amendment he proposed, and he thinks only certain people should be able to ask somebody else to perform assisted death to them. Nevertheless, he's acknowledging that for some people, if we believe in autonomy, this bill would not satisfy them. And I do think it would be intellectually coherent and more logical for proponents of the bill to want to repeal Section 2 of the Suicide Act, and I don't understand why they are not doing so. We could certainly continue to insist on prohibitions against any form of coercion or persuasion or inducement to take one's own life. But if somebody is clearly in their right mind and wants to receive assistance to kill themselves, that is the principle of this bill. And it would be neater if we amended the Suicide Act accordingly. The fact they don't want to do so suggests they see some value in the law. And that they consider that this value trumps concerns about autonomy and concerns about the impact of the law on family members who wish to travel to Switzerland to end their life. And I quite agree with them that there are such principles, namely the intrinsic value of life and the protection of the vulnerable. But I don't see why they consider that such principles do not trump autonomy when it comes to terminally ill adults in England. Thank you.
Thank you. Minister Sackman.
Thank you, and let me say that it's a pleasure to serve under your chairship. My remarks, as ever, will focus on the legal and practical impact of the amendments to assist members in undertaking line-by-line scrutiny and in exercising our duties to ensure the legislation, if passed, is legally robust and workable. The government has worked closely with the member for Spen Valley to reflect the member's intent. Chair, clause 24, as amended by amendments 504 and 505, means that individuals who assist a person to end their life in accordance with the terms of the bill are not subject to criminal prosecution. Currently, it is a criminal offence under Section 2 of the Suicide Act 1961 for a person to do an act that is capable of encouraging or assisting the suicide or attempted suicide of another person, where they intend to encourage or assist suicide or an attempt at suicide. That offence attracts a maximum penalty of 14 years imprisonment. Amendment 504 amends clause 24, subsection 1, to ensure that a person is not guilty of an offence.
Order. Order. The sitting due to the division is suspended until 4:05. 4:10. Thank you. Order. Minister Sackman.
Thank you, Chair. I was introducing Amendment 504, which amends Clause 24, subsection 1, to ensure that a person is not guilty of an offence by virtue of providing assistance in accordance with or performing a function under the bill. For example, by undertaking the first or second assessment or providing the approved substance. The purpose of the amendment, the effect of the amendment, ensures that a person is not guilty of an offence by virtue of assisting a person seeking to end their own life in accordance with the bill. And that phrase, in accordance with the bill, is absolutely key. For example, by accompanying a person to the appointment at which they will self-administer that substance. The effect of the amendment would carve out any criminal liability for such a person. As originally drafted, the wording would have limited the protection offered by Clause 24, subsection 1, to the far narrower situation of the medical professionals providing assistance under Clause 18. Amendment 504 gives effect to the Member of Spen Valley's policy intent to apply this protection to all those who provide assistance in accordance with or by performing a function under the bill. Subsection 2 clarifies that the clause does not override other ways in which a court may find a person is not guilty of an offence. Subsection 3 inserts new section 2AA into the Suicide Act. As amended by Amendment 505, this new section ensures that it is not an offence under the Suicide Act 1961 to perform a function under the bill or to assist a person seeking to end their own life by doing anything under the bill. These are for the same reasons that I set out in relation to Clause 24.1. This new section also provides a defence to the offence of encouraging or assisting suicide where a person reasonably believes they were acting in accordance with the bill and that they took all reasonable precautions and exercised all due diligence to avoid committing the offence. Taken as a package, the effect of these amendments is to make the bill legally workable, and in order to do that, it's necessary to ensure that those who assist a person to use that lawful route are not then subject to criminal liability for doing so. Clause 24, taken together with Amendments 504 and 505, give effect to that. In addressing some of the questions that were raised earlier by members opposite, there was a question as to whether there is any overlap between offences under this Act. We're going to come to some of those offences in due course in relation to clauses 26 and 27, and offences which remain on the statute book under the Suicide Act. And the short answer to her question, and I know that the member for Reigate has written to my department, and I'm sure she has a full written answer. But the short answer is that it would remain an offence under the 1961 Suicide Act to encourage suicide, including an assisted death under this bill. So to the extent that she regards that there remain any overlapping offences, that's not an unusual approach when it comes to drafting in the criminal law. But the effect of Clause 24 is that it would remain an offence to encourage someone to commit suicide under that Act. Where a person's encouragement, and I know she focused on that term, is such that it amounts to what courts would understand to be pressure or coercion, that could amount to an offence under Clause 26 of this bill when we come to that. And as I said, it's not unusual to have a degree of overlap in criminal offences. What someone is charged with and prosecuted with, again, would fall to the prosecutor depending on the specific circumstances of the case and what would be most appropriate in that scenario. I also want to address the member for East Wiltshire's scenario that he posited in relation to the pharmacist and the question of whether a pharmacist who had acted in such a way as to amount to gross negligence manslaughter, would such a person benefit from immunity from Clause 24.1 as amended? Again, with the important caveat that circumstances will depend on the particular facts of the case. The offence of gross negligence manslaughter is committed where a death is as a result of gross negligence through what would otherwise be a lawful act or omission on the part of the defendant, and where the defendant owes a duty of care to the victim. There are a number of actors within the bill's process that owe a duty of care to the person applying for assisted dying. But let's assume for a moment, under his scenario, that we do have gross negligence manslaughter on the particular facts. In those circumstances, on my reading, the government is content that the pharmacist in such a scenario could not be properly said to be performing a function under the Act in accordance with the Act. And so clause 24.1, the carve-out from criminal liability, would not apply. I think that covers most of the questions that were posited earlier. If there are any that I haven't answered, then of course I'm happy to.
Last point.
Of course.
Annie Kruger.
I'm grateful, and it might well be that she's clarified the case sufficiently, but just to, for my own sake, will she explain? She is suggesting that if the pharmacist negligently, inadvertently, but negligently, caused the death of a patient, having performed the duties under the Act, in believing they were doing so, so the death is caused inadvertently, surely they were performing duties under the Act, and therefore they would be potentially captured by the carve-out here.
So in response to that question, and again, it would depend on the actual facts, but they were intending or seeking or attempting, I should say, to perform duties under the Act, but it is highly unlikely that in circumstances where the facts establish and meet the threshold of gross negligence manslaughter, that they could be said to have carried out those duties in accordance with the Act. So they might have been carrying out duties which they thought were what the Act prescribed, but if they've done it in such a way that amounts to gross negligence manslaughter, then clause 24.1 wouldn't apply. And again, he makes the point about what the person in that scenario, the pharmacist, believes they're doing. That belief has to be reasonable. And again, that is a test that our courts are well used to applying, and it's why the amendment introduces the belief that someone is acting in accordance with the Act. It's not enough that they've got a belief that they think they're doing it. It's got to be a reasonable belief, and that is an objective standard. Those were all the observations I was intending to make, and I hope they've been of assistance. I will give way.
Rebecca Paul.
I thank the Minister for those very, very helpful clarifications. So, but can I just ask a question? So, was any consideration given to exempting encouragement as well as an offence under the Suicide Act? And I'm just interested as to why it wasn't exempted in the same way as assistance, particularly if, based on what the Minister has said, if it did potentially fall within coercion and pressure, it would get picked up as a criminal offence anyway under this new Act. And the reason I'm asking that question, I think it probably goes back, and I appreciate the Minister will be writing to me on some of this, it comes back to what is encouragement, because as the Honourable Lady for Spen Valley was setting out, that, you know...
Order. I do appreciate, but as I've said time after time, it's a question of clarification, short, rather than expanding, if the Honourable Lady will...
My apologies, it's quite a technical point, but I think the Minister understands what I'm asking. So
well, hopefully the member for Reigate has also set out her questions very fully and precisely in a letter to me, so I know what she's trying to ask, or I think I know, and I'm going to try and answer it as best I can. So, first of all, just to reiterate, as myself and the member for Aberfan Mastake have said right throughout, policy choices have been for the sponsor. The government remains neutral. As I've said, the offence of encouraging or assisted assisting suicide or attempted suicide in Section 2 of the Suicide Act is well established. Encouraging someone to go through the assisted dying process under the bill with the intention of encouraging suicide or an attempted suicide would therefore remain a criminal offence under Section 2 of the Suicide. That's what I made clear earlier. What we're talking about will always depend on the particular circumstances of the case. It's the government's view that in a scenario, and I think this is what she's getting at, where a family member or friend simply suggests to a person with a terminal condition that the option of assisted death under the bill is something that they may wish to consider and nothing more, it is unlikely and, dare I say, inconceivable that that would amount to an offence under the 1961 Act. However, where someone encourages a person in a more tangible way, such as encouraging, pressuring them to make the first declaration, that could well amount to an offence under the Suicide Act 1961. So where that type of encouragement crosses the threshold into what, interpreted in line with their natural meaning, the courts would understand pressure or coercion, that could amount to an offence under Clause 26 of the bill, which we'll come to in due course. So I hope that addresses her question, and as I said, I will set that out in writing to her, and she's welcome to write back if there's any ambiguity. I hope that assists the committee. I'm going to sit down before anybody else intervenes.
Can I just make an observation of them? I understand where the Honourable Lady's coming from, but I think if letters have gone back and forth between the department or have gone back and forth between the department and other members are not privy to what they may have been saying, it gets a little bit abstract in the debate. And so I think that's all I'm trying to get to, so we don't get it too abstract, so everybody knows what's being said. If the Honourable Lady appreciates
I thank the Chair. I was just saying that was why I was elaborating, because I wanted to make sure that everyone understood the nature of the question without having seen the letter, and in order to summarise following your instruction, I referred to the letter.
Okay, thank you. Kim Leadbeater.
I've got nothing further to add, Chair.
Thank you. Amendment 501 to clause 25, sorry, beg your pardon, wrong one. Amendment 504 to clause 24 as on the amendment paper. The question is that the amendment be made. As many as are of that opinion say aye. Aye. To the contrary, no. I think the ayes have it. The ayes have it. And I'll come to Amendment 504 to clause 24, which to Amendment 505 to clause 24, which has already been debated with Amendment 504. I call Kim Leadbeater to move the amendment formally.
Move formally, Chair.
Amendment 504 to clause 24 as on the amendment paper. The question is that the amendment be made. As many as of that opinion say aye. Aye. On the contrary, no. I think the ayes have it. The ayes have it. And I'll come to the question that clause 24 as amended stand part. The question is that clause 24 stand part of the bill. As many as are of that opinion say aye. Aye. To the contrary, no. I think the ayes have it. The ayes have it. We now come to Amendment 501 to clause 25 in the name of Kim Leadbeater, with which it would be convenient to consider amendments 502, 503, clause 25 and clause 25 stand part. I call Kim Leadbeater to move amendment 501.
Thank you, Chair. These amendments ensure that the exclusion from civil liability applies in relation to persons performing functions under the bill and persons assisting a person seeking to end their own life in connection with the doing of things under the bill. Importantly, it also quite rightly accepts from the exclusion from civil liability things done dishonestly or not in good faith and any liability arising out of negligence. The first part of the amendment, subsection 1, makes clear that anyone providing assistance to a person to end their own life in accordance with the Act will not face civil liability simply for doing so. This is crucial in offering clarity and confidence for healthcare professionals, family members or others who might otherwise hesitate due to fear of being sued for assisting a loved one or patient who wishes to end their life as a result of their terminal illness. However, while we are providing protection, the amendment does not allow for unfettered actions without any accountability. Subsection 1A ensures that any actions that are dishonest or done in bad faith are not protected from civil liability. Additionally, it states that breaches of duty of care, such as negligence, are also not exempt from liability. This provision is a critical safeguard. It ensures that while we provide legal protection for those acting with compassion and integrity, we also provide exploitation, or we also prevent exploitation or irresponsible actions by making it clear that there is no immunity for actions that are dishonest or negligent. This strikes the right balance between compassionate assistance and legal accountability. This amendment particularly reassures doctors, nurses and healthcare workers, those who are most likely to be involved in the process. Often they are deeply committed to palliative care and supporting patients through their end-of-life journey, and this amendment ensures that they will not face legal risk if they provide assistance to eligible individuals under the bill.
Thank you. Amendment 501 to clause 25 as on the amendment paper. The question is that the amendment be made. Danny Crum.
Thank you, Chair. So I want to speak to the whole clause. I just firstly welcome the amendments tabled by the Honourable Lady. I recognise that she is attempting to fix a problem with the bill, but my objection remains, I'm afraid. The fact is no other assisted suicide law in the world, including in common law jurisdictions similar to our own, like Australia or New Zealand, have such a clause. There can be no justification for it. In the course of providing assistance under this bill, a doctor commits a civil wrong. If they do that, they ought to be liable for it in the usual way. Now, I'm glad that the member in charge has realised that a total exclusion of civil liability is not justifiable, but my view is that her replacement does not go far enough. Her amendment would preserve civil liability where an act was done dishonestly, not in good faith, or for liability in tort based on the breach of a duty of care, which is, in other words, the tort of negligence. However, it is worth noting this still does exclude civil liability in other respects, and we should ask whether that's justifiable. Firstly, the clause would still exclude civil liability under a contract. So a patient who has received improper care in breach of contract would not fall within either of the exceptions of subclause 1A. I take the point that in the case of negligent care, there would often be a concurrent liability under the tort of negligence, and this is preserved by subclause 1AB. But that's not the case for other forms of contractual arrangements. So this might be particularly relevant in the situation of subcontracting. So an example would be an outsourcing company is tasked with transporting the lethal substance. Given the risks involved, the contract specifies strict rules that must be complied with. The company does not comply with those strict rules in the contract. Under the clause, even as amended, my concern is that they would not be able to be sued for this breach of contract. So what's the justification for excluding civil liability in contracts? Second, the tort of trespass to the person are commonly relevant to medical practice, as it's under such torts that cases where there was no consent or capacity are handled. Those torts can be committed recklessly, but recklessness is not the same as bad faith or dishonesty, and so liability could not be established under subclause 1AA. Such torts are also different from negligence. They do not involve a duty of care, so they would not be covered by 1AB. Now, I appreciate that in many cases liability could also be established under the tort of negligence, but that would not be the case in all cases. So I ask again, what is the justification for this exclusion? Finally, and most concerning, we were told in previous debates that if it turns out the criteria are not met, for an assisted death, one could always apply for an injunction. And leaving aside the practical obstacles and the financial obstacles involved in seeking an injunction at the last minute, which we've discussed before, my concern is that a private law injunction requires either that a civil wrong has been committed or is about to be committed. But in a case where the doctors, in good faith and without negligence, consider that the criteria has been met, but the family has new evidence to show that this is not the case, then the effect of clause 25, even as amended, is that no civil wrong has been or would be committed in that instance. So the test for a private law injunction would not be met. So I might be wrong. I would be interested to hear from the Minister. If she or the member, the sponsor, disagree with this analysis, I'd be grateful if they could point out how the private law test for an interim injunction is met in such an instance. All of this could be much simpler if clause 25 were left out of the bill entirely. In Australia and New Zealand, as I've mentioned, they do not have such a clause. not give a civil liability exception to practitioners of assisted suicide. I'm not aware of it having caused problems for practitioners. So I'd be interested to understand why we need it here. Now, I do understand, lastly, that members might be concerned about vexatious litigation, but if such claims are meritless, then there is no need for this provision. The courts already have the power to deal with vexatious litigation. And secondly, the clause with or without the amendments is not going to be enough to stop vexatious litigation if it occurs. The strongest protection that there could be would be to retain the role of the High Court judge. This way, the fact that criteria is met has been established by a court, and that makes it very unlikely that another court would want to reopen it. But we haven't done that, and we're left with this civil liability exemption, which, as I say, remains too wide. So I welcome the amendments in the name of the Honourable Lady, but they do not go far enough. I believe the whole clause is unnecessary and should be removed. Thank you.
Thank you. Jake Richards.
Thank you, Chair. Very briefly, I welcome the amendments brought by the sponsoring member to this clause. The bill as drafted, as I think the sponsoring member accepts, because of her amendments, there was an oddity there that had to be fixed. So I think these amendments do that. There is, I appreciate, some force to the honourable member's argument which was just made as to why this is necessary. And essentially that, to me, seems to be, and I'll be interested to hear what the Minister says on this, but a balancing act between ensuring that medical practitioners and clinicians are working in an environment where they do not constantly feel the heat of a lawyer's breath on their neck, but also ensuring those protections. And I think there is some force to your argument about removing it altogether, but on balance, I can see some more force in ensuring that there is clarity on that. I would just raise further issues that need to be considered in light of provision for aspects of civil liability in this process. And this is why last night I supported my honourable member's amendment, honourable member for Ipswich amendment, which wasn't passed by this committee, as to guidance for doctors in certain circumstances during this process. And I just raise these points for the record, really, and perhaps for the government and the sponsoring member to take forward as to what is the standard of care and the duty that these doctors and clinicians will be working to throughout the whole process. Now, I raise those questions not because they're unanswerable, I think they are, but we need to work out exactly what we are asking our doctors to work to and what form that guidance comes in. Does it need to be legitimised by Parliament, or can it be undertaken by a minister? I raise that now because I don't think I need to expand upon the point, Chair, greatly, but we can all imagine circumstances whereby clinicians may be compromised in their view as to what the duty of care they have to the patient. And it just needs to be very clear, as and when this process begins in our country, in this jurisdiction, what that is. Thank you.
Thank you. Minister.
Thank you very much, Chair, and it's a pleasure to serve under your chairship today, and well done for arriving on time as well, by the way. Chair, these amendments aim to ensure that, if passed, this legislation will be legally and operationally workable. I will offer a technical, factual explanation and rationale for the amendments, looking at 501, 502 and 503. These replace clause 25(1) in the bill and instead provide that the provision of assistance in accordance with the bill will of itself not give rise to civil liabilities in certain circumstances. These circumstances are where an individual provides assistance in accordance with the bill, where an individual performs any other function under the bill in accordance with the bill, where an individual assists a person seeking to end their life under the bill in connection with the doing of anything under the bill. Clause 25(1)(a) also creates an exception to the exclusion of civil liberties, providing that civil liberties can arise in cases when an act is done dishonestly or otherwise than in good faith, as well as in cases of negligence. Without this amendment, there is the possibility that clause 25 subsection 1 could provide blanket immunity to a person from all civil liberties even when they may have been negligent in their actions in providing assistance in accordance with the provisions in the bill. I hope these observations have been helpful. Thank you, Chair.
Thank you. Kim Leadbeater.
Thank you, Chair. I'll speak quite briefly on this point. I think the point that was made by the member for Rother Valley was an important one in terms of the protections that this amendment and clause provide for medical practitioners, and I do think it strikes the right balance, but clearly it's important to remove the blanket immunity. I think he refers to, the member for Rother Valley referred to, again, codes of practice, codes of conduct. We've talked a lot about good medical practice from the GMC. We've got the clause in the bill around codes of practice. So I feel confident that this clause is important and it should be in the bill, but I'm obviously still having regular meetings with officials around legal implications for the bill, so I'm happy to sort of continue those conversations, but I'm very happy that the clause as it stands serves the correct purpose. Oh, sorry, sir.
I just wanted to if she could respond possibly, and the Minister might want to respond, might want to intervene as well on this point about injunction. My understanding is that in order to obtain an injunction, you don't actually have to establish that there's either a civil wrong or a criminal offence. You have to establish that there's a serious matter to be adjudicated and there's a strong likelihood of harm taking place, and that in those circumstances a court would consider granting an interim injunction subject then to a further hearing, ex parte or otherwise, but that this idea that because it's there needs to be some kind of civil tort established is not actually correct in seeking an injunction.
I thank you for the intervention. I mean, that would be my understanding as well, but I am not a lawyer. But I think, fortunately, a lawyer has just intervened on me, so maybe he might want to step in.
I was intervening on something completely different. I was intervening on something completely different, Chair, but I will intervene on what I was originally going to. I've been reminded that in Australia there is a specific clause that relates to almost word for word the provision in this amendment. So I think the Honourable Member may be incorrect on the Honourable Member for East Wiltshire may be incorrect on some of his comments.
I thank him for the intervention. Unless the Minister's got anything to add around injunctions.
Order. Can we address it to me, please?
Sorry, Chair.
What I've said this time after time, this isn't a dialogue or a chit-chat across the chamber.
Yes.
Peter.
Thank you, Chair. Unless the Minister wants an intervention.
The Honourable may give way. Just to address this point about injunctions, which we've touched on at a number of junctures in our debates. In terms of applying for an interim injunction in a civil case, very well established test for the lawyers in the room that we all learnt at law school, the American Cyanamid test, and the first of those tests is there a serious issue to be tried? So you don't have to establish to the civil standard.
Sorry, just
forgive me. I thought I was just trying to help.
And I understand. Can we just get the order of debate in this? Members can speak. Members can stand up and speak for as long as they want in effect, on the issues they want. They may intervene to get clarity off another member if they so wish, but that's got to be short and sweet. There's nothing to stop a member standing up again and making another speech, even though they've spoken once before. So I exhort members, if they do want to get clarity, they may well want to stand up separately, unless it's a very short intervention and get clarity. They may well want to stand up again once the person sat down and make another de facto speech and get clarity through that, if it's going to be long. So if it's going to be quite a long intervention, so you're entitled to stand up in effect as much as members want. And I'm not encouraging members to do that, but that's the situation. So if the Minister in this regard wants to stand up again and clarify that of its own, in its own space, that's fine. Kim Leadbeater.
Thank you, Chair, and apologies. I thank the Minister for the intervention, and I think she did manage to make the point that needed to be made.
Thank you. I hope that was of some help. I might repeat it again in due course. So we now have Amendment 501 to Clause 25 as on the amendment paper. The question is that the amendment be made. As many of that opinion say aye. Aye. Contrary, no. And I think the ayes have it. The ayes have it. We now come to Amendment 502 to Clause 25, which has already been debated with Amendment 501. I'll call Kim Leadbeater to move the amendment formally.
Move formally, Chair.
Amendment 502 to Clause 25 as on the amendment paper. The The question is that the amendment be made. As many as of that opinion say aye.
Aye.
On the contrary, no. I think the ayes have it. The ayes have it. We now come to Amendment 503 to clause 25, which has already been debated with Amendment 501. I call Kim Leadbeater to move the amendment formally.
Move formally, Chair.
Amendment 503 to clause 25 as on the amendment paper. The question is that the amendment be made. As many as of that opinion say aye.
Aye.
On the contrary, no. I think the ayes have it. The ayes have it. We now come to question 25 as amended, stand part. The question is that clause 25 stand part of the bill. As many as of that opinion say aye.
Aye.
Contrary, no. No. Okay. Division. Lock the doors.
Jack Abbott. Aye. Lewis Atkinson.
Aye.
Lambos Cherylambos.
Aye.
Daniel Francis.
No.
Tom Gordon.
Aye.
Sarah Green.
Aye.
Rachel Hopkins.
Aye.
Sojan Joseph.
Aye.
Stephen Kinnett.
Aye.
Danny Kruger.
No.
Kim Leadbeater.
Aye.
Kit Malthouse.
Aye.
Sarah Olney.
Aye.
Dr. Simon Ofer.
Aye.
Rebecca Paul.
No.
Jake Richards.
Aye.
Sarah Sackman.
Aye.
Liz Saville Roberts.
Aye.
Naz Shah.
No.
Dr. Neil Shastri Hurst.
Aye.
Dr. Marie Tidball.
Aye.
Sean Woodcock.
No.
The ayes were 17, the noes were 5, so the ayes have it, the ayes have it. Unlock. We now come to Amendment 506 to clause 26 in the name of Kim Leadbeater, with which it will be convenient to consider Amendments 507, 508 and 509 and clause stand part. I call Kim Leadbeater to move Amendment 506.
Thank you, Chair. These amendments to clauses 26 and actually 27 to some degree, which I'll come on to shortly, are intending to clarify offences under the law. The changes have refined the language to ensure that offences relating to dishonesty, coercion and pressure are more clearly defined. And I'm going to serve to, the amendments serve to clarify the details of 4 categories of offences, and I'll provide a summary of the 4 categories now. The first category is when someone would dishonestly, by coercion or pressure, induce another person to self-administer an approved substance. This offence, in clause 26, subsection 2, is the most serious offence of all. It is coercing or pressuring someone to take their own life. It would include coercive control and pressure, and it attracts as the maximum a life sentence, the most severe punishment the law can impose. The second category of offences include dishonestly by coercion or pressure inducing another person to make a first or second declaration or not to cancel such a declaration. Clause 26, subsection 1. This is where the criminal conduct has coerced or pressured someone to execute or not cancel the declarations, a step in the process but not actually, i.e. a step in the process but not actually ending their own life. This is the second most serious offence and attracts a maximum of 14 years in prison. The third category of offences involve making or using a false instrument, first declaration, second declaration, medical report within a 6-month or less diagnosis, or failing to notify of the cancellation of a relevant cancellation with the intention of facilitating the provision of assistance under the Act. That actually comes under new clause 24, which is in the next clause, but it's important, I think, to look at the offences in the round. This is the third type of offence. It's a new offence, and it covers cases where a person helps another person to obtain assistance under the Act by falsifying documents to get that assistance or to prevent it being removed. This is still very serious and attracts a maximum sentence of 14 years. It will most often be applied where the person seeking the assistance wishes to get round the safeguards. These safeguards must be rigorously enforced, hence the same maximum as the second category of offence. The fourth category of offence involves making or knowingly using a false instrument which purports to be a first declaration, second declaration, I'm struggling with that word this afternoon, or certificate of eligibility, or relevant medical certificate, or willfully ignores a cancellation of a first or second declaration, or fails to comply with the cancellation. This fourth category of offence is designed to deal with any failure with knowledge to comply with the requirements of the Act in relation to documentation. This carries a maximum of 5 years in prison. This is different from category 3 because it does not depend on proving the intention is to facilitate the provision of assistance. This is designed to deal with any case where the doctor or other person knows there is something wrong with the relevant document, yet continues to use it or inserts material into the document which is false. It does not matter why they have done it. Chair, the original draft had a potential life sentence for someone who uses the false instrument with the intention of causing death. Having spoken to criminal law experts and recognised the need for differing degrees of seriousness, I consider the life sentence should be available, but for the most serious offence, which is coercing or pressuring someone to take their own life. That is reflected in the offence, clause 26, subsection 2. Chair, of the 4 sentencing categories in the bill, categories 2 and 3 carry the same maximum sentence as the current assisting encouraging offence under the 1961 Suicide Act. Therefore, 2 and 3 correctly mirror the activity under the existing law. However, category 1 exceeds anything in the current law. This is because the bill, for the first time, captures coercion and control in the way that so many who are cautious about the bill want, and I agree with this. In other words, the protection for the vulnerable enshrined in the new bill goes further than existing law. That is why the bill is the answer for those who worry about terminally ill people who may succumb to family pressure to end their life. Category 4 is also new. So the types of offending and the sentencing powers that follow mean the bill is comprehensive and it caters for levels of seriousness where the current law is silent. I'll come on briefly to Amendment 509, which ensures that prosecution for any offence under this clause can only be initiated by or with the consent of the Director of Public Prosecutions. This is an important safeguard, ensuring that prosecutions are handled with the utmost care and consideration. By involving the Director of Public Prosecutions, we make sure that decisions to prosecute are made fairly, consistently and with proper oversight. This also aligns the approach to assisted dying with the principles of prosecutorial discretion seen in the Suicide Act 1961. This will ensure that cases are reviewed for their individual circumstances before a decision to prosecute is made, ensuring the individual circumstances of a case are assessed based on the case's merits. The amendments refine and clarify the bill's provisions by ensuring that legal terminology is more precise, penalties are more aligned with the seriousness of offences, and stronger oversight mechanisms such as the DPP's consent for prosecutions are in place. They aim to protect the integrity of the assisted dying system while offering greater accountability, punishment and deterrence against fraudulent or coercive practices. Thank you, Chair.
Thank you. Amendment 506 to clause 26, as on the amendment paper, the question is that the amendment be made. Rebecca Paul.
Thank you, Chair. I just wish to speak fairly briefly, just firstly to say I welcome Amendment 508. I think this absolutely makes sure that an offence committed is given the serious result, the conviction that it needs to have. But I think just one of the things I want to say is that it's not just the strength of the sentences that we need to think about, it's also about how difficult it can be to detect and demonstrate coercion in the first place. So domestic abuse prosecutions have followed an overall downward trend over the last decade, according to Women's Aid. A report from the Domestic Abuse Commissioner in January of this year found that the criminal justice system is unfit to hold abusers to account and safeguard domestic abuse victims.
domestic abuse victims are being failed by the criminal justice system at every stage, from police to probation. Victims routinely face a lack of specialist service referrals, poor enforcement of protective orders, court delays and early release of abusers as they seek safety and justice. The Commissioner also found that just 5% of police-recorded domestic abuse offences reach conviction, and less than a fifth of victims have the confidence to report to the police in the first place. And within the police workforce itself, only 4% of alleged domestic abuse perpetrators are dismissed. Women's Aid say that trust in the criminal justice system is at an all-time low, with domestic abuse survivors not feeling that they will be believed and supported when reporting abuse. This is even more challenging for black and minoritized survivors who are faced with additional barriers and poor responses when they seek help. In written evidence...
give way.
I will, of course, give way.
I thank you for giving way, and she's making a point which we've covered several times during the debate already, and it's a very important point, but hopefully she's reassured by these offences included in the Act, which create sentences which just don't currently exist.
I thank the Honourable Lady, and I absolutely am reassured by your amendment, and I welcome it. But I do think it's just worth bringing attention to the fact that the sentence is important, but also identifying that coercion and pressure can be quite difficult too. So in written evidence, a social worker called Rose cast doubt on the workability of the bill. She was writing when the High Court safeguard was still part of the bill, so we need to bear that in mind. But what she says applies to the panel as well. And she says, and I quote, based on lived experience, there is no authentic provision, mechanism or route that cheaply and swiftly would allow an approved palliative care professional or social worker to act to protect a vulnerable person under the grounds of coercion. Place yourself in a position of being sick or older, coerced by family for financial gain, or by a practitioner wanting to save public costs to pursue assisted suicide. The social worker senses it by body language, a squeezing of their wrists, a sharp silencing look. Can you see a judge saying the social worker sensed a tension in the air and a look? Do you think that would serve to reach the threshold to override a request for assisted suicide in a court of law? In practice, what would happen would be the social worker would record her concerns on the system, share them with her manager, who will go to her manager who will say, we do not have funds to consult legal and your evidence provided does not reach threshold anyway.
Order. I'm generally trying to give as much latitude, but the issue of coercion has come up before. In the context of the fence, I'm not sure this is necessarily pertinent or relevant, if that's the word I can use. So can the Honourable Lady just bear that in mind during her speech, please? Thank you.
Okay. I thank the Chair. I will stop there in that case. I just was making the point that this is important. I will just, in terms of proposed amendment 509, with respect to proceedings for an offence under this section may be instituted only by or with the consent of the Director of Public Prosecutions. It would be useful, I would find it useful to have more clarity around how that is used currently, why that is used, and why it is therefore appropriate to use it in this instance. And these are all genuine questions. I simply just don't know. So I would be grateful for some input on that, but I will leave it there. Thank you.
Tony Kruger.
Thank you. Thank you, Chair. I'd just be grateful if the Minister, in winding up, or the member could explain the situations in which behaviour criminalised by clause 26(2) of the bill would not also amount to an offence under section 2 of the Suicide Act as amended, or indeed murder. What behaviour would be criminalised here that is not already criminal? If there's any instance that the member can think of where there would be no crime under Section 2 of the Suicide Act, but there would be an offence under Clause 26(2), it strikes me that if there isn't, and I can't think of it, then at least in respect of coercion and pressure, the offence that's created here is redundant and duplicative. And ministers have rightly stressed the importance of their duty to the statute book. My understanding is that having redundant or duplicative legislation, or indeed duplicative offences, would be inconsistent with the duty that we have to the statute book. And one might ask, what does it matter? Wouldn't it be helpful to have belt and braces, additional safeguards in the bill? I agree in principle, but I note that when other members have deployed this argument in regards to adding in terms like undue influence and so on that we have done, the neutral ministers have rebuked them by suggesting that by appealing to the duty that we are supposed to have to the statute book. So I think the point cuts both ways. Why are we embroidering the bill with duplicative offences? Embroidering the statute book, indeed.
Would you give way on that?
Happy to give way.
Thank you, Chairman. I'm just slightly confused. I would have thought, given his views on the bill, that this is something you would really welcome as to having in the bill, an actual offence for the purposes of this Act. Surely that's something that we should all support.
Well, I support the principle of insisting that by dishonesty, coercion or pressure inducing people to kill themselves it should be illegal. But my understanding is that it already is. And if it's not illegal, if there are circumstances in which we need this additional offence, I'd like to understand what those are that is not already captured by the Suicide Act or the law on murder. And as I just said, while it might be helpful to duplicate the offence, I understand the very sensible convention in our law is that it's not helpful to have two offences for the same act, because of the opportunity, which I'll come to, for offenders to, as it were, play off one offence against the other. So having duplicative criminal offences can make prosecuting cases harder, because the defendant can raise abuse of process arguments about whether they've been charged with the most appropriate offence. That's why I understand usually the Attorney General's Office, the Ministry of Justice, are very keen to avoid duplicative offences. Now, an example of the difference in terms of the treatment of the offence, it's proposed that this offence be subject to a life sentence, and that requires the consent of the Director of Public Prosecutions. But at least in the one case where it overlaps with murder, this would provide a more favourable treatment for the accused than the other obvious charge. Can this be justified? Duplicating criminal liability by introducing new offences has far-reaching implications that can disturb the coherence and certainty of criminal law. If one introduces a law that gives prosecutors two criminal offences to choose from that cover one act, some prosecutors will choose one and some will choose another. This is generally undesirable and indeed unprecedented in the case of homicide, where there is every reason to suspect it could cause chaos for grieving families in search of justice. Such chaos is all too predictable for a number of reasons. Let me give an example. A defendant proven to have procured a suicide by deception will be well advised to plead guilty to the offence contrary to section 26(2) and then contest any attempt to introduce murder proceedings. So this matters profoundly. A decision to prosecute is an administrative decision and is subject to judicial review. This is not an academic point. It could cause real distress for bereaved families in deep turmoil seeking justice. This is an example. Let us imagine a person A is a new coercive and controlling partner of person B and procures by deception their suicide in order to profit from a will. The family of person B grows suspicious and provide the police with a convincing case for a murder prosecution. The CPS agree and charge B with murder. B accepts they procured the suicide by deception and on this basis appeals, seeking a remedy in judicial review, saying the CPS should have charged him with clause 26(2) offence, not murder. The JR is backed by wealthy pressure groups, beset with administrative adjournments and so on. From the filing of the claim form to the final judgment of the administrative court within the High Court, the case takes 24 gruelling, painful, awful months for the bereaved family. Throughout this time, lawyers for B, for the defendant, tell him to stay the course, continue to offer the plea to section 26(2), because the family will be exhausted by the reality of litigation. The family have no legal aid, no support, no charity backing them, no one interested in their case, and the war of attrition in litigation finally defeats them. They advise the CPS they would accept a plea to section 26(2) under the Section 22 offence and not the murder that actually occurred. This is the reality of duplicating criminal liability. In this example, B has got away with murder by judicial review. So, Mr. Chair, we must be clear about what we're being asked to do here, and it is not simple. We are being asked to innovate in the law of murder. We are being asked to do so without the assistance of the Law Commissioner, without the careful eye of legal or judicial bodies alive to the difficulties of duplicating liability, and without the input of any bodies that represent the victims of crime and how this might affect them. There are no government consultations before us with such bodies, and there's no expert assistance from judicial or legal figures as to how the good intentions around Clause 26.2 might unintentionally lead to serious and undesirable consequences such as I've described. We cannot legislate in the dark on a matter so serious. If the law of murder is to be altered so fundamentally, these questions cannot remain open. They cannot be passed over to the CPS and the judiciary, and they cannot be left like a ticking time bomb for someone else to address. So whether committee members support or oppose this legislation overall does not matter for these purposes. There is a direct challenge here to the integrity of the statute book. We cannot risk I'll finish here. We cannot risk an innovation in the law of murder with the unintended consequences that some murders go unprosecuted, unpunished. We must pass quality law that solves rather than create problems. Now, I don't intend to oppose the amendments except the one on the DPPs. I don't see why the consent of the DPP should be required in the case of dishonesty, coercion or pressure. It's good that there's clarity on what people are prohibited from doing, but I'm anxious that the government discharges its duty to the statute book and that it does so in an even-handed manner. Thank you.
Thank you. Now, Sharp.
Thank you, Chair. That was really interesting. I thank the member for East Wiltshire because he's actually raised some concerns for me. I'm rising to speak in support of the amendment, but also raising some points, and I share the concerns. So if I may just speak to the bits that I feel I can support and I'm really pleased with. My honourable friend will obviously explain these amendments later, and she already has done some of it, but they do tidy up errors in the original bill's construction. As it was originally written, subsection 2 quite rightly makes it an offence if a person, by dishonesty, coercion or pressure, induces another person to self-administer an approved substance provided in accordance with this Act. Unfortunately, in the original bill, the penalty for such an act was only a prison sentence of 14 years. It's quite right that this is a penalty for the offence detailed in subsection 1. And that's when someone uses dishonesty, coercion or pressure to get another person to make a first or second statement, but doesn't actually succeed in getting them to the end of the assisted dying process. Going back to the amendment, I think it's easy to be agreeable to 14 years and is an inadequate penalty for successfully coercing or pressurising somebody into an assisted death, and I'm glad that my honourable friend recognised this problem and brought forward an amendment that imposes a maximum penalty of life imprisonment for such offence. And I am going to come back to that point in terms of life imprisonment in particular. My honourable friend for Sunderland Central gave a powerful speech to his committee the other day. He said that abusive or coercive people are already likely to be forcing their victims to starve themselves or refuse treatment. That is true, and I thank him for raising that important point. I would welcome all measures which made it harder for abusers to do that, and I will gladly work with honourable members to do so. But I do want to sound a strong note of caution. Creating an offence and giving it a strong maximum penalty is only one of the ways to deter abuse and coercion, and it's perhaps the easiest thing to do. And I did mention this in a previous speech, that we've only got I think it's around 4% convictions when it comes to coercion. There are other things that we need to do to deter and prevent abuse. We need the people who may come into contact with it to be aware of what could happen. We need them to be able to spot the signs that it may be happening, and we need ways to investigate those signs carefully. Only when we've done those things can we move on to the CPS potentially prosecuting somebody for an offence. And then, if they are found guilty, to the court sentencing that person. Those are matters that this clause deals with, and they come at the end of a process. I welcome the amendments my honourable friend has accepted from my honourable friend, the member for Lowestoft. They make training in domestic abuse and coercion mandatory for professionals working on assisted dying cases. But more new training will not be enough on its own to make it near impossible for abusers to succeed. Having had lots of experience, unfortunately, in this area, having seen it in my own life and the lives of people close to me and the lives of constituents, sometimes abusers are not subtle. But even so, they can be hard to catch because their victims are unwilling to recognise that they, well, it's not being unwilling, I think it's more of, they just can't see, they can't recognise that they are being abused. And, you know, the classic for, if I could have £1 for every time I heard he's changed, or, you know, for hundreds of justifications. And sometimes abusers are very subtle indeed. They can be the ones that are very hard to catch, or they may never be caught at all. I've heard honourable members say that, in fact, this bill, and I think the honourable member for Spen Valley said earlier, that this bill, it actually strengthens the safeguards around people who are terminally ill, because we haven't got them there in the first place. But that's just for, and I do appreciate that idea, but it is just for those people who are terminally ill. So I'd like to really see how we can strengthen that for people in not just those that are terminally ill, but for wider, generally speaking as well. It does offer a new opportunity to, in some ways, it offers a new opportunity for somebody to be coercive and controlling and be dishonest in that way. That is why I have, so many times, speaking bluntly, been banging on about safeguards throughout this committee. And perhaps, you know, I'd like to think people don't find it a bit much, but I say this, because abusers are very, very persistent, and they're very clever people. That means we have to be clever and persistent in the ways that we devise our safeguards against abusers. So while I welcome this clause, and I welcome my honourable friend's amendments, I'm still disappointed that we rejected other safeguards. I still say the panel procedure could and should be much tougher. That would also not guarantee and that it caught abusers, but it would be more likely.
Order. Members cannot continue to talk about amendments and affect the substance of amendments that have already been rejected, and we're now going into that territory. So I'm not going to stop the honourable lady from talking about it, but I do give her an indication that rehashing debates about amendments that we've already had is not for us today.
I apologise, Chair, and I will not refer to them moving forward. I just want to come back to the point which, listening to the member for East Wiltshire in particular, about the issue of DPP consent. And it does worry me, and I'd be grateful to the Minister to pick some of those queries up if we are, because what we do in this place is we make laws, and my experience of the forced marriage law, because I was a victim of forced marriage, was we made a law but we actually never got any convictions. We got very little moved on it because we actually already had laws in place to prosecute for that offence, and it was, and I'm not saying that this is necessarily happening here, but I just want to draw the committee's attention to the fact that are we making a law which is already existing? If it already exists for the Suicide Act, then are we just making a law for the sake of putting something on the statute books or on the face of this bill? Because we've talked a lot about, you know, we shouldn't be complicating things. We shouldn't, you know, complication, the word has been used quite a lot in the debate. So are we adding another layer of complication when it comes to putting that on the face of a bill, when we're not prepared to do it for other things which people feel strongly about? Because in all fairness, this is also something that already exists. I do want to understand the DPP consent, because my understanding is so if we were prosecuting, say for coercion, which unfortunately we've only got 4% of prosecutions for coercion, would that wouldn't, my understanding is that wouldn't need DPP consent. It would be needed potentially for suicide, assisting somebody in suicide per se, but it wouldn't be needed for coercion. So is there some clarity needed about the application of law? Because I wouldn't want to see the idea for somebody, if we had that scenario where somebody was actually murdered, and that was murder, it was premeditated, it was thought through. Somebody thought through the process of how to use this process as an avenue to kill that person. Would that then, that I would not want us to be making a law that would then allow somebody to get away with murder, literally. And I think there's some more thought to be given to that. And I'm not the expert, and I'm not the eminent lawyer like the Minister is, but it does concern me from the from the member for East Wiltshire's comments, and just having looked a bit closely at that. So I would be really welcoming if the Minister could comment to that when she rises. Thank you.
Thank you. Jake Richards.
I'm grateful, Chair. And Chair, you've intimated that we can speak for as long as we want. I'm not going to speak for long on this clause, partly because I fear that we are making a bit of a mountain out of a molehill here. This clause attempts to create new offences, criminal offences, serious offences. I'm not a criminal lawyer. That's what it intends to do, and from reading the clause and from seeing the proposed amendments, that's what it does. And criminal offences are legislated for an array of reasons. But one, in my view anyway, and it's a good reason, is to provide a deterrence for committing such an offence. We are entering, if this law receives royal assent, new ground. We are developing a new process in our healthcare system that will affect how our society works, how our culture works. We are creating a new legal process, which we've had lengthy discussions about when discussing new clause 12, as I call it, but the panel debate. In my mind, it's wholly appropriate to have an offence which specifically looks at this very new area. I can't see any weight to this argument that it undermines the law of homicide in our country, in our jurisdiction. And I cannot see how members, and I do mean this with respect, but how members who have been worried about this bill, understandably worried and have concerns, cannot see that this only goes to strengthen it. And arguments that this somehow undermines the law of murder or homicide, I would gently say is slightly disingenuous. And this is a clause which, in my mind, I hoped would have been a straightforward debate that would have seen that clearly strengthens the safeguards around assisted dying. And I hope that the committee can support them.
Thank you, Chair. I've taken your advice because mine would have been a long intervention. But I just want to, first of all, can I just gently remind the member, I think the idea that we've not used the word disingenuine in this debate and this bill, and I think that is, I sincerely hope wishes he reflects upon that. Because I think everybody in this committee that I know is genuinely, regardless of the debate we're having, we are all very committed to what we're doing here. So that's the first thing I'd like to say. The second thing I'd like to say is, in terms of creating a new, making this a mountain out of a molehill, so we have, having given it further thought, and again, I've only just given this thought during this debate, the truth is that when it comes to, and I'll give again the issue of forced marriage, the legislation with which I am familiar with, that was legislation that was put before the House, went through the House, and what police forces had was already legislation which prosecuted for forced marriage. The thing what we should have done as legislators, as government, we should have ensured that we raised awareness and trained our police officers, trained our the community that we live in to apply that law.
We're dealing with Clause 26 and the amendments to that, specifically in relation to these offences. So, and the amendments. Can the honourable lady please speak to the clause and the amendments, please?
I am speaking to the clause, Chair. Apologise. I'll make it more. I'll try to be more clear. So, in relation to this amendment, we have a clause which creates a new offence. And the example I'm trying to give back from that, when we passed legislation in the past, that speaks to the same principle of what this amendment is talking to. So if we are creating a new offence which the DPP needs to consent to, and we've already got an offence, then are we complicating it for the CPS or indeed our police officers if we are not already? So take the issue of coercion, because that is what this amendment speaks to. So the issue of coercion, we only have 4% conviction rate on the issue of coercion. We also have, when it comes to assisted death, we have people, but the Honourable Member for Spen Valley referred to a horrific case of a lady who's been investigated, and she talked about her husband's death. In that case, we need to be clearer about what this act, what this amendment will lead to. What does it actually protect? Are we protecting those cases, in the case what the Honourable Member for Spen Valley referred to earlier, or are we making it more complicated for our law enforcement to police this? Because ultimately, this amendment, this legislation, if it passes this House, that is what it will mean for us. It will mean real-time legislative changes and potential cases to prosecute. That's my point, Chair. I hope that is okay. Thank you.
Minister.
Clause 26, as amended by amendments 506, 507, 508 and 509, creates two standalone criminal offences that apply when a person uses dishonesty, coercion or pressure to induce a person to do a particular act. Subsection 1 creates an offence of inducing another person to make a first or second declaration or not to cancel such a declaration by dishonesty, coercion or pressure. This offence, as we've heard, would carry a maximum penalty of 14 years imprisonment, ensuring consistency with the maximum penalty under the Suicide Act. Subsection 2, as amended by Amendment 506, creates an offence of inducing another person to self-administer an approved substance provided under the bill by dishonesty, coercion or pressure. Amendment 506 replaces in accordance with under to this offence. This gives effect to the member for Spen Valley's policy intent that the offence should capture those who induce a person to self-administer a substance that, due to some error in the process, had not been provided strictly in accordance with the processes in the bill. This amendment therefore will make sure that the offence in clause 26.2 will operate effectively. Amendment 508 inserts a new subsection 4 to establish life imprisonment as the maximum penalty for the offence in subsection 2. This amendment gives effect to the member for Spen Valley's policy intent for emphasising that inducing someone to undergo an unwanted assisted death through a legal system established by Parliament is a grave offence, warranting the most severe penalty of life imprisonment. Amendment 507, which is consequential on Amendment 508, amends subsection 3 to reflect the sponsor's policy intent that the offence in subsection 2 should carry a maximum penalty of life imprisonment rather than 14 years imprisonment. Amendment 509, which a number of members have raised, amends clause 26 to provide that neither of the offences could be prosecuted without the consent of the Director of Public Prosecutions. This amendment is to achieve the member for Spen Valley's policy intent that the legislation firstly be consistent with the Suicide Act 1961, which makes the same provision for the DPP's involvement and where that consent is required, and to ensure that spurious prosecutions are not brought. So, for example, by those who may oppose the process that the applicant for assisted dying is undergoing, simply because they oppose it rather than because of any illegality or criminality. That is the function of having the DPP consent baked into the legislation. It should be made clear that the terms coercion, dishonesty and pressure remain undefined in clause 26. This was an issue that, of course, we touched on right back in the early days of clause 1. Without a statutory definition, the terms will carry their natural, ordinary meaning, well understood by both the public and the courts alike. There were two other points that I wanted to pick up that were touched on by various of the speeches. The issue of coercion and how coercive control and the subtleties, the way that is dealt with, and indeed the painfully low conviction rates for domestic abuse and coercion. I'm not seeking to make a wider political point beyond the amendments that we're discussing, but the Honourable Member for Reigate and the Honourable Member for Bradford West will know that the government has a mission to halve violence against women and girls, and I can assure her, in my capacity as Minister of State and the Ministry of Justice, that we are intently focused on addressing that and making sure that the criminal justice system plays its part more widely. And so it's in that context that these offences sit. The other point that I wanted to address and touched on earlier was the point raised by the member for East Wiltshire in terms of our duties to the statute book. It is right that there is a degree of duplication, and it's right to acknowledge that. The government, in working with the sponsor member to reflect her policy intent, acknowledges that. But this is not unusual. It is something that those within law enforcement, in particular in the CPS, are well versed in. It will be for them to make the appropriate charging decisions depending on the facts in the particular case. And the function of the offence created under clause 26.2 and indeed the penalty attached to it affects the gravity of the offence that the sponsor sought to indicate for the offence of inducing someone to undergo something through dishonesty, coercion or pressure in the context of what we all acknowledge as a new process, which if passed would be a new legal regime for assisted dying. The manipulation of such a new regime to the ends that are criminalised under that provision is reflected in that specific offence. So just to be clear, the duplication of or the degree of duplication is acknowledged, but it's also the government's view that that is neither unusual nor that it poses a problem for the CPS. I will give way.
Thank you. Danny Kruger.
I'm grateful to her, and that is helpful and does make sense. The only justification for duplication must be that the duplication is only partial, which she's just suggested it is, that there's not a complete overlap, and that there will be some cases which will fall into one case but not into the other. So I wonder if she could help us to understand an example of a case to help the CPS when they're making their decisions about which offence to charge somebody under. An offence that would be illegal under this clause, that would not be already illegal under either the Suicide Act or the laws of homicide.
Minister.
I'm actually not going to answer that question directly because I'm not going to get into hypotheticals which would test. I understand the question he's asking me. As I said, the policy intent here and the policy of including the specific offence within the context of this new legal regime and the signal that it sends to all those participating in this regime by attaching the severest penalty of life imprisonment to the offence created under clause 26.2 has been a matter for the sponsor, and the government has worked with her in a way to create a workable regime. I'm not going to, on my feet, proffer a hypothetical factual scenario which would be caught by this offence but wouldn't be caught under other offences which exist within our criminal law. The point is that overlapping criminal offences exist within our criminal law. It's not unusual. The CPS is well versed in dealing with it. The charging decisions will be for the CPS with the consent of the DPP. And in terms of satisfying the purpose of having criminal liability, both to catch those who perpetrate what would be, on any view, a heinous crime, but also to deter such crime would be discharged by the drafting that we've got here. I will give way.
Danny Kruger.
I'm grateful, and I do respect the difficulty of the position she's in, but I'm afraid I do think that we do have to consider hypothetical scenarios because we are creating law here. Does she acknowledge that even if she can't imagine or can't suggest to us a case in which there is somebody falls into the provisions of this clause but is not caught by the Suicide Act or law of murder, somebody who is being charged with murder could legitimately or plausibly claim that in fact they should have been charged with the offence under under subsection 2 here, and could plausibly make a case, perhaps through judicial review, that the charging decision was wrong, and that we could have months of litigation before we even get to the prosecution beginning. Can she envisage that scenario might happen?
I don't find that plausible. I find that highly implausible. What I find plausible is the likelihood that the CPS would apply the appropriate charging decision to fit the facts as they've arisen. If they've arisen within the context of this legal regime, someone acting nefariously, dishonestly, coercively through the assisted dying, then the charge under 26, clause 26 would be the appropriate one. And I find it implausible that that scenario would arise. And as I said, they are well versed at applying the appropriate charging decision to the appropriate crime on the facts of the crime. And I'm not going to speculate or hypothesise on what that would be.
I mean, I wonder if the Minister would agree with me. This is not, as she said, an unusual exercise for the CPS and operates in lots of other areas. So, for example, CPS regularly make decisions about whether to charge GBH Section 18 or Section 20, both forms of GBH, but it depends on the circumstances, the seriousness, the level of intent, as to which one they choose. And as she said, that the charging naturally, whether it falls in the same act or different act, comes down to the circumstances.
That's a good example, and one knows from charging decisions that often in an indictment one might have multiple offences to capture the totality of the criminal behaviour. Some of those may be made out, some of them may not. I think what the government has sought to do here, working with the sponsor, is to reflect her policy intent that the gravity of an offence within this wholly new legal regime, where we are sanctioning new conduct, something which is, as he himself has pointed out in earlier debates, decriminalises what has previously been criminal, but making sure that it captures what would be criminal within the new legal regime. It's important from the sponsor's point of view to signal that the government has worked with her, and the government's position is that if you like, the result of that in this amended form of the bill gives both satisfaction to her policy intent, but is also compatible with how our criminal law routinely works and is workable from the point of view of the CPS as well. I'm happy to do it.
I'm very grateful again, and I acknowledge the point that she's making. Just to my right honourable friend's point, nevertheless, we're not talking about two categories of offence within the same legal framework, namely GBH, but two different legal frameworks altogether: the law of homicide and the law of around assisted dying. And does she agree with me that what we're doing here through this new clause is creating the opportunity for a murderer who would otherwise be convicted or charged with murder to claim that in fact he was committing an offence under the assisted suicide law? So we're creating a new opportunity for somebody who would otherwise, if it wasn't for this law, be legitimately charged with murder to actually claim that they're committing this offence instead.
I don't consider that we have, through this amended form of the bill, if the committee chooses to vote on it, created an opportunity that could be exploited in that way. He makes the point earlier that there hasn't been consultation on this point. What there has been is the close working of highly experienced government lawyers together with the sponsor to reflect her policy intent. What I think that that clause 26, interlocking and indeed overlapping, as I've acknowledged, with the Suicide Act does, is to prescribe new forms of criminal offence and liability which would capture criminal behaviour, which is ultimately what this is about. And tellingly, the punishment attached to the 26 offence is the same as the maximum punishment for murder, that of life imprisonment, which I think is indicative of the gravity of the offence that would be caught by this.
Would you give on that point? I think that's the point I would like to make, if I may, Chair, is that actually the penalty is the same. But I think it's really important that this offence is specific, and hence why I'm putting it on the face of the bill. But the point is the outcome for the criminal involved would be the same.
Minister.
Chair, that is all I intended to say on this matter, and I think we've probably ventilated that particular issue as far as we can take it.
Thank you. Kimberly Lee-Peter.
I've got nothing to add, Chair. Thank you.
Thank you. Amendment 506 to clause 26 as on the amendment paper. The question is that the amendment be made. As many as are of that opinion say aye. Aye. To contrary, no. I think the ayes have it. The ayes have it. We now come to Amendment 507 to Clause 26, which has already been debated with Amendment 506. I call Kim Leadbeater to move the amendment for me.
Move for me, Chair.
Amendment 507 to Clause 26, as on the amendment paper. The question is that the amendment be made. As many as of that opinion say aye. Aye. On the contrary, no. I think the ayes have it. The ayes have it. We now come to Amendment 508 to Clause 26, which has already been debated with Amendment 506. I call Kim Leadbeater to move the amendment for me.
Move for me, Chair.
Amendment 508 to Clause 26, as on the amendment paper. The question is that the amendment be made. As many as of that opinion say aye. Aye. On the contrary, no. I think the ayes have it. The ayes have it. We now come to Amendment 509 to Clause 26, which has already been debated with Amendment 506. I call Kim Leadbeater to move the amendment for me.
Move for me, Chair.
Amendment 509 to Clause 26, as on the amendment paper. The question is that the amendment be made. As many as of that opinion say aye. Aye. On the contrary, no. 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 Division. Division. Lock the doors.
Jack Abbott. Lewis Atkinson. Bambos Sharalambo. Aye. Daniel Francis.
Aye.
Tom Gordon.
Aye.
Sarah Green.
Aye.
Rachel Hopkins.
Aye.
Surgeon Joseph.
Aye.
Stephen Kinnock.
Aye.
Danny Kruger. No. Kim Leadbeater.
Aye.
Kit Malthouse.
Aye.
Sarah Olney.
Aye.
Rebecca Paul.
Aye.
Jake Richards.
Aye.
Sarah Sackman.
Aye.
Liz Silver Roberts.
Aye.
Naz Shah.
Aye.
Dr. Neil Shastri Hurst.
Aye.
Sean Woodcock.
Aye.
The ayes were 19, the noes were 1, so the ayes have it, the ayes have it. Unlocked. We now come to the question that Clause 26, as amended, stand part. The question is that Clause 26 stand part of the bill. As many as of that opinion say aye. Aye. On the contrary, no. I think the ayes have it, the ayes have it. We now come to Amendment 381 to Clause 27, which has already been debated with Clause 12 stand part. I call Kim Leadbeater to move the amendment formally.
Move for me, Chair.
Amendment 381 to Clause 27, as on the amendment paper, be made. As many as of that opinion say aye. Aye. On the contrary, no. I think the ayes have it. The ayes have it. Thank you.
Musical chairs.
We now come to Amendment 510 to Clause 27 in the name of Kim Leadbeater, with which it would be convenient to consider Amendments 511, 512 and 513. I call Kim Leadbeater to move Amendment 510.
Thank you very much, Chair. These amendments relate to the falsification or destruction of documentation, and I believe are very straightforward. Amendment 510 is a drafting change which aligns the wording used with wording elsewhere in the clause. Amendment 511 and Amendment 512 clarify that the offence under subsection 2 relates only to an opinion about a matter relating to a function under the bill rather than the person. And Amendment 513 clarifies the scope of the offence under subsection 3 by providing that the offence occurs where a doctor fails to comply with a notification or recording obligation in relation to the cancelling of a first or second declaration. These amendments significantly improve the clarity, scope and precision of the offences in Clause 27, aligning the language of the rest of the bill and ensuring it is more consistent. They refine the original provisions, focusing on serious misconduct and offences covered by this clause. Thank you, Chair.
Amendment 510 to Clause 27 as on the amendment paper. The question is that the amendment be made. Danny Cooper.
Just quickly, thank you, Chair. No, very good to see you this evening. I mean, no objection to these amendments. The Honourable Lady's tabled. Nevertheless, I do think there is value in broadening the offence to include actions performed intentionally or recklessly. And it's critical for patient safety. Given the finality of the result of assisted death, there should not be any room for carelessness. And liability must make sure that not only deliberate misconduct, but also negligent record keeping is subject to legal scrutiny. I just wanted to place on record the evidence we've had from the British Journal. We saw in the British Journal of Nursing has documented the serious risks of poor record keeping in medical practice, demonstrating how inadequate documentation contributes to clinical errors. This is not just a matter of bureaucratic tidying up, and I think the Honourable Lady recognises that. The principle is straightforward. If the decision to assist in ending a life is to be lawful, documentation supporting it must be unimpeachable. So expanding liabilities to cover reckless documentation is entirely consistent with existing legal and professional standards in the UK medical profession. Thank you.
Sarah Sackman.
I can be brief. It's a pleasure to serve under your chairmanship. Clause 27, as we've heard, creates various standalone criminal offences regarding the falsification or destruction of documentation related to assisted dying. Amendment 510 replaces willfully with the wording intentionally or recklessly committing this offence, and that aligns the wording with that used elsewhere in the clause. The rest of the amendments are ones in which the government has worked with the sponsor to, in effect, tighten up and improve the workability and operability of the bill.
Kim Ledbetter.
I've got nothing further to add, Chair.
Amendment 510 to clause 27, as on the amendment paper. The question is that the amendment be made. As many of that opinion say aye. Aye. To the contrary, no. I think the ayes have it. We now come to Amendment 511 to clause 27, which has already been debated with Amendment 510. I call Kim Ledbetter to move the amendment formally.
Move formally, Chair.
Amendment 510 to clause 27, as on the amendment paper. The question is that the amendment be made. As many of that opinion say aye. Aye. On the contrary, no. I think the ayes have it. The ayes have it. We now come to Amendment 512 to clause 27, which has already been debated with Amendment 510. I call Kim Ledbetter to move the amendment formally.
Move formally, Chair.
Amendment 512 to clause 27, as on the amendment paper. The question is that the amendment be made. As many of that opinion say aye. Aye. On the contrary, no. I think the ayes have it. The ayes have it. I now come to Amendment 513 to clause 27, which has already been debated with Amendment 510. I call Kim Ledbetter to move the amendment formally.
Move formally, Chair.
Amendment 513 to clause 27, as on the amendment paper. The question is that the amendment be made. As many of that opinion say aye. Aye. On the contrary, no. I think the ayes have it. The ayes have it. We now come to Amendment 514 to clause 27 in the name of Kim Ledbetter, with which it would be convenient to consider Amendments 515, 516 and new clause 24. I call Kim Ledbetter to move Amendment 514.
Thank you very much, Chair. The combination of Amendments 514 to 516 and new clause 24 refines and strengthens the legal framework surrounding assisted dying, shifting the focus towards serious fraudulent misconduct, falsification of documents, and ensuring that prosecutions are conducted with careful oversight by the Director of Public Prosecutions. These changes mark a clear departure from the original clause 27, which focused more generally on non-compliance with administrative duties and introduced more severe consequences for deliberate wrongdoing related to the assisted dying process. New clause 24, I think, is an important addition to the bill. It creates a new clause which creates an offence in respect of certain conduct where the person engaging in the conduct does so with the intention of enabling another person to obtain assistance under the Act. I did make some comments on this previously, so I will keep it there for now, but I hope that members of the committee can join me in supporting these amendments and this new clause.
Amendment 514 to clause 27, as on the amendment paper. The question is that the amendment be made. Minister Sackman.
Madam Chair, I intend to be brief. This is new clause 24 and amendments 514 to 516 create standalone criminal offences relating to the falsification, destruction of documentation where a person acts with the intention of facilitating the provision of assistance to another person under this bill to end their own life. This reflects the Member for Spen Valley's policy intent that those who falsify documents with a specific intent of facilitating another to end their life should be subject to a higher maximum penalty than those offences in clause 7. And Madam Chair, I think that's all I have to add.
Kim Ledbetter.
Nothing further to add, Chair.
Amendment 514 to clause 27 as on the amendment paper. The question is that the amendment be made. As many of that opinion say aye. Aye. To the contrary, no. I think the ayes have it. We now come to Amendment 516 to clause 27, which has already been debated with Amendment 514. I call Kim Ledbetter to move the amendment.
Move formally, Chair.
Amendment 514 to clause 27 as on the amendment paper. The question is that the amendment be made. As many of that opinion say aye. Aye. On the contrary, no. I think the ayes have it. We now come to Amendment 516 to clause 27, which has already been debated with Amendment 514. I call Kim Ledbetter to move the amendment formally.
Move formally, Chair.
Amendment 516 to clause 27 as on the amendment paper. The question is that the amendment be made. As many of that opinion say aye. Aye. To the contrary, no. I think the ayes have it. The ayes have it. We now come to the question that clause 27 as amended stand part. The question is that clause 27 stand part of the bill. As many of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. We now come to Amendment 153 to clause 28, which has already been debated with Amendment 144. Okay, we're not doing that one. You let off. We now come to Amendment 442 to clause 20 in the name of Rachel Maskell, with which it would be convenient to consider amendments 443, 444, 445, 521, 485 and clause 28 stand part. I call anyone to move amendment. Sean Woodcock.
I'm very grateful, Jen. It's a pleasure to have you there for the rest of the proceedings today. I rise to move Amendment 443, tabled by my honourable friend for York Central. It ensures that the drugs used for assisted death would be approved by established regulatory bodies. We know from evidence provided from other countries that have assisted dying laws that the lethal drugs used can result in uncomfortable complications, even if only in a minority of cases. None of us would wish for this to be the case should this legislation be introduced. Unfortunately, the data on assisted dying recipients suffering complications is nowhere near as thorough as we would like it to be, but the data does still show us some important facts about what some people go through during the assisted dying process. The latest annual report on assisted dying from the state government of Western Australia, for example, states that, and I quote, "No data on length of time to death, administration location or complications is collected by the Voluntary Assisted Dying Board regarding deaths occurring via self-administration of the voluntary assisted dying substance." The Western Australian Authority do gather data on the rate of complications among assisted dying recipients who receive practitioner-assisted deaths, where a doctor administers the drug. They found that in 4.3% of these assisted deaths in 2023, the patients suffered complications. Those complications included, again I'm quoting from the report, page 40, worsening of pain or discomfort and regurgitation vomiting. Other complications reported including coughing and or burning of the throat following assisted oral injection, hiccups with gastric reflux, involuntary muscular contraction and delayed loss of consciousness. All patients with reported complications died after administration of the voluntary assisted dying substance. Now, I understand, of course, that this bill does not propose that a doctor would administer the substance themselves, but I don't think that means that the Western Australia data is irrelevant. Whatever drugs are administered under this bill will likely be similar or the same to those as administered in Western Australia. If this bill passes, some of the people who undergo assisted dying in England and Wales are likely to suffer the same kinds of complications. For those reasons, we cannot allow drugs to be prescribed in order to end people's lives without first undertaking the most rigorous of tests. In particular, we need to investigate how likely they are to give the patient a prolonged death or to worsen the patient's pain. Expert pharmacologists who sent in evidence to the committee also stressed the need for thorough investigation of the drugs that would be used for assisted dying. In written evidence submission number TIAB 255, 17 clinical pharmacologists noted that a 2018 review of Canada's assisted dying law came to some disturbing conclusions. The review of the Canadian experience found the overall, to quote, overall, the quality of the evidence for their use is low. Most available evidence is unpublished or limited to expert opinion, observational data and experiential data.
Would you give way?
I wouldn't have to give way.
Thank you for giving way. He's making some interesting points, but I think this is probably the debate we had the other day around clause 18. This clause is actually about the prescribing, dispensing and transporting of the approved substances rather than the substances themselves.
I don't accept that it's not relevant to this clause, I'm afraid, but I take on board your point. If I can finish my quote, there is some difficulty in determining which coma-inducing mixture has the most evidence, based on the lack of comparative data between each drug regime and different dose trials. In their evidence, the pharmacologists continued, monitoring of drug efficacy and safety should be compulsory in order to assure good clinical care and to comply with the regulation. I agree with that sentiment, and again, I hope that all honourable members would as well. The right institutions to approve drugs before use and then to monitor their safety during use are those that are named in this amendment. All substances used for assisted dying must be approved through the Medicines and Healthcare Products Regulatory Agency and either the National Institute for Clinical Excellence or the All Wales Medicine Strategy Group processes. There are significant risks if this rigorous process is not undertaken. The drugs used for assisted dying must be tested to ensure they are safe and effective for use in assisted death. Happy to give way.
I'm very sorry to intervene on the Honourable Joe with the statement. This section is not about the formulation of the drugs or the approval of the drugs. This is about the administration of the issuing of the drugs by a pharmacist or otherwise. And I'm sorry if I'm misconstruing him, but I think he might be off on a bit of a tangent in a debate, as the Honourable Lady said we've had earlier. This is about, as I say, the bureaucratic process of the issuing of the drugs, not about their formulation or approval.
I would suggest that the...
Sean Woodcock, before we go, can I just ask Honourable Member if we could talk about the transporting of the drug and not the drug itself?
Okay.
And then we will stay in scope. Sean Woodcock.
Okay, I mean, I would suggest that part of the bureaucracy,
Mr. Woodcock, it's not up to you to make those decisions.
In response to the honourable gentleman, of course.
I'm speaking, Mr. Woodcock.
Of course.
I've given an instruction. It is your job to take that instruction. Thank you. We can stick to the amendment.
I understand. Well, I've said what I need to say on the amendment. I believe that it is relevant. I believe that but I take the advice of you as chair, but I put it before the committee.
Sarah Sack. Oh, sorry, Sergeant Joseph. Sorry, Amendment 442 to close 28 is on the amendment paper. The question is that the amendment be made. Sergeant Joseph.
Thank you, Chair. I rise to in support of these amendments because I believe prescribing, dispensing, transporting medications of these medications are very important, and I think these amendments are also very important. We have, in my own experience, and the CQC report, one of the area in many health settings has issues with storing and disposing medications. So this medication, if I'm talking about the clause, the amendment 442, it's a straightforward amendment, just asking to change the may to must. I think it should be a straightforward amendment that it should be the Secretary of State must, by regulation, make those provisions. Moving on to the amendment 444, during the oral evidence, we heard that from Australia that there was one incident of medication was given to the patient who did not take the medication and patient passed away, but her partner took that medication and he was died. So I think this is a very important amendment that the substances should not be left unsupervised by medical practitioner at any time. So I urge the committee to accept that amendment. And also the next amendment, which is the 445, also instead of asking to change the may to must. So some of these are very straightforward, but it's very important to safeguard the relatives, staff, and public. We cannot leave these medications unattended any time. Thank you, Chair.
Danny Kruger.
Thank you, Chair. Pleasure to follow the honourable gentleman. The honourable gentleman who spoke before him. I entirely concur with their points, and particularly that deriving from the expertise of the honourable gentleman. I want to speak to the group as a whole. These are very important amendments. They do concern, in a sense, the heart of the bill, which is the management of the lethal drugs that we are talking about. And the question remains open of what drugs we are talking about, which is a cause of deep concern to me. But whatever they happen to be, we need to make sure that the management, the regime of dispensing, transporting, prescribing is a safe one. So without reprising the details of all of the amendments, the purpose of them is to ensure a stricter and more transparent and safer regime for the management of these drugs. And Amendment 521 in my name would ensure that the regulations that we arrive at are laid before Parliament, that they are debated and approved by both Houses of Parliament. Amendment 485 in the name of the member for York Central addresses the same issue. And the amendments seek to address the dangerous absence of an adequate regulatory regime in this bill for the lethal drugs and approved substances. Once again, in this clause, significant questions are ignored. And ministers will be given the power to make regulations for the prescription, dispensing, transportation, storage, handling and disposal of approved substances. And the clause is envisaged as sufficient for an entire regulatory regime for approved substances. It's just 87 words. It's as if it's an afterthought. As is the role of pharmacists, by the way, and the regulations are subject to the negative procedure. Highly unlikely to be to be debated at all or voted upon for reasons given in my earlier complaints about the use of the negative procedure. And indeed, it's discretionary whether these regulations will be made at all. Now, last night, the Minister told us that the government objected to the Medicine and Healthcare Products Regulatory Agency, the MHRA, approving the drugs or substances in the amendment that I had laid. And I quote from the Minister, the government's assessment of Amendment 465 is that it would significantly impact the legal and operational delivery of the bill. The government anticipate that all substances used for assisted dying will have existing licences from the MHRA for other indications. But the amendment would require the approved substances to be licensed by the MHRA specifically for the purpose of assisted dying, which was indeed what the purpose of that amendment was. And if there's anxiety that I'm somehow straying off the relevant clause in the amendment, which I detect from members who are clearly looking forward to their dinner, I do insist that this is, well, with respect.
Mr. Kruger, can we please stick to the point?
Oh,
thank you.
Certainly. Sorry, Madam Chair, I don't appreciate the sense of impatience that is in the committee. These are very important matters. These amendments
Can
matter.
we just stick to the point, Mr. Kruger?
Absolutely, I'm doing so, yes. That is what I'm doing. So I referenced the debate that we had last night, which I hope is within scope, because the suggestion has been that, that the bill either insufficiently addresses the need for a regulatory regime for the approval of drugs specifically for the purpose of assisted dying, or the government is saying that the drugs' existing licences are sufficient for these purposes. So I want to know, is it the government's position that there will be no regulator involved, and this will sit entirely with the minister, as this clause does? Now, if regulators are to be involved, will further legislation be needed? So, I won't repeat evidence from the Royal Pharmaceutical Society concerning the legal arrangement, but I want to quickly refer to evidence submitted by Mary Stapleton, a pharmacist with more than 30 years' experience in clinical governance, who made the point that based upon a preliminary review of current published data, it is difficult to see how the regulatory and professional standards for prescribing and dispensing unlicensed drugs can be met. Further evidence to that effect from the Royal College, Royal Pharmaceutical Society, from pharmacists and barristers. But let me conclude with this point. Given that there is so little on the face of the bill and no guardrails for the use of the power which will be given to the Secretary of State, why is the negative procedure judged appropriate for something of this significance? It cannot be argued that the negative procedure is needed in this case because the amendments might need to be made quickly and frequently. That can't be the case. We haven't yet authorised the regime. The negative procedure would allow the Secretary of State quite unjustified ability to change these processes without any requirement for a parliamentary debate or vote. So Lord Hermer, the Attorney General, has said that this government, this new government, will take a new approach, considering, and I quote from him, the real need to consider the balance between primary and secondary legislation, which in recent years has weighed too heavily in favour of delegated powers. Excessive reliance on delegated powers, Henry VIII clauses or skeleton legislation upsets the proper balances between Parliament and the Executive, criticism of the previous government there. This not only strikes at the rule of law values I've already outlined, this is Lord Hermer, but also at the cardinal principles of accessibility and legal certainty. In my view, he says, the new government offers an opportunity for a reset in the way that government thinks about these issues. This means, in particular, a much sharper focus on whether taking delegated powers is justified in a given case, and more careful consideration of appropriate safeguards. So I conclude with the question to the Minister. Has she considered the advice of Lord Hermer in coming to a view on the appropriateness of this clause and the powers taken in the way that they have been? As the Hansard Society note, the government has an overriding duty of care to the statute book. As such, any powers that may accrue to ministers because of a private member's bill must be acceptable to the government. It must therefore take a view on the powers and their scrutiny. So, on the sufficiency of this power, has the sponsor or the minister consulted with the Royal Pharmaceutical Society? Has sufficient work been done to look at the workability and operationalisation of this clause? So I hope the committee will join with me in supporting these amendments.
Minister Kinnock.
Thank you very much, Chair, and it's a great pleasure to serve under your chairship today. Looking at Amendment 442, this would require that the Secretary of State make regulations for the prescribing, dispensing, transporting, storage, handling and disposal of approved substances, including the keeping of records relating to these activities. This differs from the current approach of the bill, which enables the exercise of a power by the Secretary of State to make such regulations. In practice, where the Secretary of State makes regulations specifying substances for the purpose of the Act under Clause 20, the Secretary of State will necessarily also make regulations for the prescribing, dispensing and transporting of said substances under Clause 28. However, requiring rather than enabling the regulations under Clause 28 to be made may reduce flexibility in terms of their timing, as there are a range of technical issues that may need to be resolved, for example, clinical questions as to how an approved substance should be prescribed or dispensed. Turning to 443, this would require that regulations for prescribing and dispensing of approved substances can only be made in relation to substances that have already been approved by the Medicines and Healthcare Products Regulatory Agency, MHRA, and National Institute for Clinical Excellence, NICE, or the All Wales Medicine Strategy Group, AWMSG. This may impact the operational delivery of the bill, as the drafting is ambiguous. One possible interpretation is that the amendment may require the approved substances to be licensed by MHRA specifically for the purposes of assisted dying. This would require additional powers to amend medicines regulations, which are not currently provided for in the bill. NICE and the All Wales Medicine Strategy Group typically only make recommendations on medicines that have already been proven to be safe and efficacious. They do not approve medicines in the way that this amendment implies, and this could potentially infringe upon the role of the MHRA. Turning to 444, as the bill currently stands, the Secretary of State may, by regulations, make provisions relating to the prescribing, dispensing, disposal and transporting of approved substances. If this amendment is accepted, regulations made by the Secretary of State relating to the transportation, storage, handling and disposal of approved substances would need to specify that approved substances must at no time be left unsupervised by a medical practitioner. The operational impact of the amendment would be to place a duty on a medical practitioner to ensure that approved substances must at no time be left unsupervised. This would have the effect of increasing the obligations on the coordinating doctor and potentially any medical practitioners with access to approved substances. It is unclear when the duty on the medical practitioner would apply. For example, when the approved substance is in transit or only once it's been provided to the person. I will declare.
Now, Sean.
I thank the Minister for giving way. Would the government's intention not be to sign this over to a regulator?
Minister Kinnock.
I thank her for that intervention. Well, my understanding of the amendment is that it would place the duty on a medical practitioner. So I'm speaking to the purpose and effect of the amendment, which isn't about a regulator, it's about a medical practitioner. Does that help answer her question?
I'm not sure, but I'll give it more thought.
The amendment to clause 28, this is 445, this amendment would require that the Secretary of State make regulations about enforcement, including provision imposing civil penalties when making regulations for prescribing, dispensing, transporting, storage, handling and disposal of approved substances, including the keeping of records relating to these activities. This would be a change from the current approach in the bill, which gives a power to the Secretary of State to make such provisions. In practice, where the Secretary of State makes regulations specifying substances for the purpose of the Act under Clause 20, the Secretary of State will necessarily make regulations under Clause 28 for the prescribing, dispensing and transporting of said substances and on enforcement, which would include imposing civil penalties. Turning to 521. This amendment... Yeah.
I'm grateful, and just further to the intervention of the Honourable Lady, just be grateful to understand from the Minister whether he does envisage that an independent regulator of any sort would be responsible for overseeing the regime that we currently don't know what that will be. The future Secretary of State will design it. Does he envisage there will be some sort of regulatory body with that job, and if not the MHRA, who?
I thank him for that intervention. I think we're, I can't remember the clause number now, but when we get to the clause number, which is about the way in which the system will work, and specifically the NHS and how that's going to work, as 32, isn't it? That's right, clause 32. I think that the role of regulation will absolutely be discussed and debated in that context. So my sense is that it would be best to confront that issue 39. In the clause of 32 and 39. Officials are currently working with the sponsor of the bill. We know that the policy intent of the sponsor is for this to be a service that is in an integral part of the NHS, but with some flexibility in the way it is actually delivered, and I think we've briefly touched on that in previous debates in this committee. Clearly, as an integral part of the NHS, it will have to be a regulated service based on the foundations of the way in which the NHS is regulated more broadly. So I think the answer to his question is basically yes, but I think that the right place to debate this and to potentially amend the bill would be in those clauses.
Danny Kruger.
I'm grateful to him. Just following up on that, and we look forward to the amendments which the government is working on. But does he envisage that there will be amendments to the NHS Act itself as part of the amendments that are coming forward?
It needs to be part of the amendment, not speculation about the future. Minister Kinnock.
Well, thank you, Chair. I think that's actually helped me to answer the question that I precisely how I was probably in a far more pithy and direct way than I would have to the honourable gentleman. But that I think is the case. It's I think best for us to wait to 32 and 39, and we can really get into the meat of the precise issue that he has raised. On 521, this amendment changes the requirements in clause 28 so that regulations governing the prescribing, dispensing, transporting, storage, handling, disposal and records relating to approved substances under the bill must be laid in draft form and approved by resolution in each House of Parliament. This is a change from the current requirement in the bill that the regulations are subject to the negative procedure. Both procedures are subject to parliamentary scrutiny. However, the requirement for active debate in both Houses of Parliament as a result of the amendment would extend the timeline to make or change regulations. Turning to 485, this amendment is similar to 451. It alters the requirement in clause 28 that regulations governing prescribing, dispensing, transporting, storage, handling, disposal and records relating to these activities of approved substances are subject to the affirmative procedure instead of the negative procedure as drafted. Similar to the change of procedure proposed by Amendment 521, the affirmative procedure would extend the timeline to make or change regulations. Clause 20, that's it. I was going to talk about Clause 28 Stamp Part, but I don't have anything to add on that, Chair, so that is the end of my observations. I hope they were helpful to the committee. Thank you.
Kim Ledbetter.
Thank you, Chair. I will speak briefly to Amendments 485 and 521, where I will respectfully disagree with the Honourable Member for East Wiltshire, not for the first time. I believe the negative procedure is perfectly adequate in matters of this kind, and I think we had a similar debate about this the other day. And I will also speak to Amendments 442 and 445 in the name of the Honourable Member for York Central. Whilst I take on board the comments of the Minister about time pressures, I'm minded to support both those amendments because regulations are important, and I think I have no problem with placing a duty on the Secretary of State in those two instances.
Danny Kruger.
I'm grateful. It might appear a sort of procedural issue, but does she acknowledge there is a profound difference between a negative and an affirmative procedure? Why is she content that the regime for the regulation of these lethal drugs, that are the absolute core of her bill, should be subject to the discretion of the Secretary of State without any likelihood or any real possibility of any sort of debate in Parliament? Why shouldn't it be through the affirmative procedure?
Kim Ledbetter.
I mean, I'm not aware of any situation where we would debate drugs for any other type of medical provision or health care. And I appreciate the gravity of the situation, but I think, with all due respect to colleagues, we are not best placed to make those kinds of decisions, and it's unnecessary for us to have that debate. I think clinicians and experts in pharmacology and in medicines are best placed to do that under the guidance of the Secretary of State.
Danny Kruger.
Nevertheless, she is proposing that it passes through Parliament, just through the negative procedure. So she thinks that there is an appropriate rubber stamp by Parliament. Parliament needs to approve this regime. Why should it not have the opportunity to debate it?
Oh, as I've said, I think that's the correct level of parliamentary involvement in that process.
Sean Woodcock.
I have no further to add, Chair.
Do you intend to move?
443.
You withdraw?
No, I'll be moving it.
Okay. Amendment 442 to clause 28 as on the amendment paper. The question is that the amendment be made. As many of that opinion say aye? Aye. To the contrary, no. I think the ayes have it. We now come to Amendment 443 to clause 28, which has already been debated with Amendment 442. Does any member wish to move the amendment formally? Amendment 443 to clause 28 is on the amendment paper. The question is that the amendment be made. As many of that opinion say aye? Aye. On the contrary, no? No. Division.
Division room 10.
Lock the doors.
Jack Abbott. No. Lewis Atkinson.
No.
Bambos Charalambos.
No.
Daniel Francis.
Aye.
Tom Gordon.
No.
Sarah Green.
No.
Rachel Hopkins.
No.
Surgeon Joseph.
Aye.
Stephen Kinnock.
No.
Danny Kruger.
Aye.
Kim Leadbeater.
No.
Kit Malthouse.
No.
Sarah Olney.
Aye.
Rebecca Paul.
No.
Jake Richards.
No.
Sarah Sackman.
No.
Liz Silver Roberts.
No.
Naz Shah.
Aye.
Dr. Neil Shastri Hurst.
No.
Dr. Marie Tidbull.
No.
Sean Woodcock.
Aye.
The ayes 6, the noes 15. The noes have it. Unlock. We now come to Amendment 444 to Clause 28, which has already been debated with Amendment 442. Does any member wish to move the amendment? We now come to Amendment 445 to Clause 28, which has already been debated with Amendment 442. Does any member wish to move the amendment?
I'll move that amendment.
Amendment 445 to Clause 28 as on the amendment paper. The question is that the amendment be made. As many of that opinion say aye. Aye. On the contrary, no. I think the ayes have it. We now come to Clause 521. Amendment 521 to Clause 28, which has already been debated with Amendment 442. Danny Kruger, do you wish to move the amendment?
Thanks, move.
Amendment 521 to Clause 28 as on the amendment paper. The question is that the amendment be made. As many of that opinion say aye.
Aye.
On the contrary, no.
No.
Division. Lock the doors.
Jack Abbott.
No.
Lewis Atkinson.
No.
Bambos Charalambos.
No.
Daniel Francis.
No.
Tom Gordon.
No.
Sarah Green.
No.
Rachel Hopkins.
No.
Surgeon Joseph.
No.
Stephen Kinnock.
No.
Danny Kruger.
Aye.
Kim Leadbeater.
No.
Kit Malthouse.
No.
Sarah Olney.
Aye.
Dr. Simon Ofer.
No.
Rebecca Paul.
Aye.
Jake Richards.
No.
Sarah Sackman.
No.
Liz Silver Roberts.
No.
Naz Shah.
No.
Dr. Neil Shastri Hurst.
No.
Dr. Marie Tidbull.
No.
Sean Woodcock.
No.
The ayes 3, the noes 19. The noes have it, the noes have it. We now come to Amendment 215 to Clause 28, which has already been debated with Amendment 187. I call Kim Leadbeater to move the motion formally.
Move formally, Chair.
Amendment 215 to Clause 28 as on the amendment paper. The question is that the amendment be made. As many of that opinion say aye. Aye. On the contrary, no. I think the ayes have it. We now come to the question that Clause 28 as amended stand part. The question is that Clause 28 stand part of the bill. As many of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it, the ayes have it. We now come to Amendment 552 to Clause 29 in the name of Danny Kruger, which has not been grouped with any other amendments. I call Danny Kruger to move Amendment 552.
522, is it not? 522.
Sorry? 552. Oh, it's 522. It's written 552, yeah.
Okay. Thank you, Chair. My amendment would leave out subclause 1 of clause 29, and I'd like to read part of a letter to the editor of the Telegraph written by the former Chief Coroner of England and Wales, Thomas Teague Casey. He writes, Clause 29 of the bill would prohibit a coroner from investigating any death where the duty to do so arises only because the deceased died as a consequence of the provision of assistance in accordance with the bill. But for that clause, the coroner would be under a statutory the coroner would be under a statutory duty to investigate such a death, and if satisfied at inquest that the deceased had used an approved lethal substance to end his or her life with the intention of doing so, would be obliged to record a conclusion of suicide. Since the coroner's jurisdiction affords a powerful deterrent against malfeasance, the public may wonder why the bill proposes to abandon such a robust safeguard. The approval of the High Court is no substitute, as it would be given in advance of death and could offer no assistance. Yes, indeed. Well, we've scrapped the approval of the High Court, but it would have been no substitution. It will be under the panel system. It could offer no assurance that the assistance had been provided in strict compliance with the law, or that the circumstances of the case had not changed following the court's declaration. If the bill becomes law, who will provide the necessary posthumous judicial scrutiny of these unnatural deaths? So that's the suggestion for the point made by the former Chief Coroner, which I regard as powerful. My amendment seeks to reverse the situation as in the bill, and to ensure that there is a proper referral to the coroner and that the recording of the death is suicide. I can imagine three possible objections to this. The first is that it is not the lethal substance that killed the person, but it's their terminal illness. Points often been made that they are dying anyway. But the rest of Clause 29 essentially admits that this is not the case. The amendment it would insert to the Births and Deaths Registration Act would provide that the cause of death would be recorded as assisted death, along with the note of the terminal illness. So it's a recognition that something else has happened to the patient, not just the illness that they were dying from naturally. The second objection is that this is not suicide, and so it should not be investigated as such. And we've been over this topic ground frequently. I'm afraid the fact that the amendments to the Suicide Act had to be made in the bill does give the game away on that. So we are left with the third objection, that it is not necessary or it's overly burdensome to insist on this usual step in the event of suicide. But given the concerns that have been expressed about this piece of legislation, I do agree with the former Chief Coroner that there ought to be some posthumous judicial scrutiny, especially as we've now removed the pre-death judicial scrutiny in the form of the High Court judge. I won't cite the evidence we've received from witnesses that have supported or objected to this clause and supported my amendment, Centre for Women's Justice, among others. But I will note that some supporters of assisted dying who have written to us have concerns about this subclause, and Professor Ahmedzai, who we heard from in the oral evidence sessions, strong supporter of assisted dying, he told us in written evidence that deaths from assisted dying should automatically be referred to the local medical examiner, and if that professional has any reason to doubt that the procedures were not followed, there should be an automatic referral to the coroner. So he is suggesting that the referral to the coroner should happen.
Kim Ledbetter.
Sorry, that is indeed what would happen under the bill as it stands.
Danny Kruger.
Yes, I'm grateful. So the concern is that it should be automatic, and I'm just citing Professor Ahmedzai's recognition of the frequent necessity or the distinct possibility of a referral to the coroner being appropriate, and my suggestion is that that should happen as a matter of course. I mean, I would be grateful to understand from the member or the minister under what circumstances they feel a coroner should be involved, under what circumstances it would be appropriate. And the difficulty I have is we're putting a lot of emphasis on the role of the local medical examiner to decide whether or not it should be appropriate for the coroner to consider a case. My suggestion is that they should be considered in all cases. I don't think this needs to be an overly burdensome obligation on coroners. Some coroners' inquests can be dealt with in as little as 20 minutes if matters are simple and not in dispute, which they would be in the great majority of these cases. But the presence of this jurisdiction, the ability of the coroner to investigate, would be a most valuable safeguard. It would also help identify if matters have gone wrong in the act of self-administration and the process of dying, which could significantly assist whatever the regulatory regime we're yet to discover oversees the process, could assist the continuous improvement of the regime. It would also help identify issues relating to misdiagnosis, which we know can happen in many cases, which is remarkable and is worth pointing out again to suggestion that terminal diagnoses are always accurate. In one study, 1 in 4 cases were found after autopsy to have been misdiagnosed. So doctors might say that somebody is dying of a certain condition, it turns out they weren't. Now, I do take the point that a coroner would not be prohibited by subclause 1 from launching an investigation in appropriate cases. But given that you do not know what you do not know, it might be hard to decide when this is required. So with a new scheme like this, Madam Chair, it would be better to start with an investigation in every case, and then it might be that in a few years' time it appears that this is not needed. Then a future Parliament could change the law to reduce this safeguard, but I do implore the committee to consider that we should start with the safest bill we can. Thank you.
Amendment 522 to clause 29 as on the amendment paper. The question is that the amendment be made. Minister Sackman.
Thank you. Under the Coroners and Justice Act 2009, coroners have a duty to investigate and certify deaths which are reported to them and which trigger their duty to investigate, i.e. where they have a reason to suspect that the deceased died a violent or unnatural death, or the cause of death is unknown, or indeed the deceased died while in custody or otherwise in state detention. There are also regulations made under powers in the 2009 Act that require medical practitioners to notify such deaths to the coroner. Clause 29(1), unamended, of the bill disapplies the coroner's duty to investigate in the case of an assisted death, which has been carried out in accordance with the provisions of the bill. In practice, this would mean that the assisted death would instead be certified by an attending practitioner, that is to say, the doctor who has attended the patient, and scrutinised by an independent medical examiner working within the NHS. Therefore, the attending practitioner and medical examiner, rather than the coroner, would certify the cause of death. It would remain open to anyone, that could be a family member, it could be a medical practitioner who's interacted with the deceased but who has concerns, to report a death to the coroner if they had concerns that it had not occurred in line with the provisions of the bill. Amendment 522 would remove the disapplication of the coroner's duty to investigate in relation to assisted deaths, essentially reversing the provisions in the bill as currently drafted. Consequently, and given that assisted deaths are inherently unnatural, this amendment would require that the coroner would have a duty to investigate each and every assisted death and would then certify the cause of death. As I've already said, the bereaved family would be able to raise any concerns in relation to his point, the member for East Wiltshire, would be able to raise any concerns with the medical examiner, and the coroner's duty would be to investigate would be triggered if they suspected that the death hadn't occurred in line with the process prescribed. It's important to note, of course, that medical examiners follow a structured process of investigation of their own, reviewing medical records, consulting with practitioners involved in the case, and then applying the criteria set out in the Notification of Deaths Regulations 2019 to determine whether the death meets the threshold for a coroner referral. And in so doing, they would proactively be speaking to family members, thereby providing the opportunity for any concerns to be raised, and if there are any concerns, to make that referral to the coroner. I hope that assists.
Kim Ledbetter.
I'll just speak very briefly. So my understanding, maybe I think I heard the Minister say this, we're correct in saying the attending practitioner or the medical examiner or anybody else for that matter, including family members, could refer to the coroner if it was felt necessary or if there was any suspicion of anything untoward. If that's the case, then I'm content that the bill as it stands is fit for purpose.
Danny Kruger.
I'll just quickly respond to that, Madam Chair. My concern is, as Thomas Teague said, that without the clause, the coroner would be under a statutory duty to investigate. I recognise there is the opportunity for an investigation if the family member or the medical practitioner, it's unlikely the medical practitioner who's overseen the death, they might decide to refer it to a coroner, suggesting that they themselves had somehow failed in their duty, or there'd been a complication they couldn't have dealt with. But the fact is that the only way a coroner would get involved under the bill as it stands is if they conclude that there's something wrong on the basis of not knowing what has happened because they haven't haven't performed any investigation. So the purpose behind the amendment is to ensure that there is a statutory duty for the coroner to review the death. I also think, I think it's a point of principle that it's appropriate to record the death as suicide, because that is what has happened, assisted suicide. Nevertheless, Madam Chair, given the state of the debate, and I suspect that I'm not in a majority in supporting this amendment, I don't propose to push it to a vote.
Is everyone content with the amendment to be withdrawn? Aye. We now come to Amendment 273 to Clause 29 in the name of Sarah Olney, with which will be convenient to consider Amendment 274 and new Clause 10. I call Sarah Olney to move Amendment 273.
Thank you very much, Chair. It's a pleasure to serve under your chairmanship. We've already discussed the importance of collecting good information on the operation of assisted dying throughout the course of this committee, and I know that honourable members will agree with me that understanding the impact of legislation on society, for better or ill, helps us to improve its operation and respond to any urgent issues which arise. To this end, my amendments and new Clause 10 specify that a few more pieces of information must be recorded by the doctor facilitating an assisted death. Recording the method, the time taken, and noting any complications is not overtly onerous on the coordinating doctor, but these three pieces of information could be crucial to uncovering which drugs are most appropriate. It will also enable us to understand more broadly if those who are having assisted deaths are having good deaths. It would be deeply unfortunate if we were to introduce a mechanism intended to help those likely to die in great pain or with indignity, only for that mechanism to offer some patients an alternative kind of painful death. One of the ways we can learn which methods of assisted death are the most humane is to make careful notes of any complications and the time taken to die. It's also critical that we understand a wider social picture of this significant social change. In particular, with regards to equality considerations, are there groups who are being excluded from assisted dying, or are there groups who are overrepresented? Should we treat one group's overrepresentation as a demonstration of good access to this service, or should we see it as a failure elsewhere in the system? We can only understand how those who face discrimination in our society are impacted by this bill if we collect this data, and that is what my amendment proposes to do. Dr. Jamila Hossain told us in the oral evidence, racism is also a specific issue within palliative care. We did a survey post-COVID of staff across the nation working in palliative care. More than 1,400 people responded. The vast majority, more than 80%, were white British, but 40% said that they had witnessed or experienced racism within the end-of-life care sector. For ethnic minority groups, that is much higher. That leads to mistrust. I work in Bradford. We have lots of patients who are ethnically diverse in the hospital. Almost every week, one of the first things I have to reassure patients about is that I cannot legally do anything to shorten their life. This is front and centre of the fear for those patients, and we see it all the time. As Dr. Hussain highlighted, there and at other points, racism exists within the palliative care sector. And if we want to tackle discrimination, then recording ethnicity and requiring the Voluntary Assisted Dying Commissioner to analyse this data would help in this regard. Dr. Sarah Cox told us we need to make sure there's not inequity in palliative care, so that you do not have to be white and rich and have cancer to get good palliative care, because the consequence of failing on palliative care provision will lead to more people feeling that they have no choice but to end their lives early. And it would also help us to understand the impact on women of this legislation. I'm pleased that the committee approved the amendments proposed by the member for Lowestoft concerning training on coercive control and domestic abuse. The need for this amendment highlights the intersection between misogyny and the abuse of assisted dying, about which the member for Bradford West has spoken so compellingly at different points in this committee. And so understanding how this law is affecting and interacting with women in particular seems to me to be relevant and necessary. If we are to ensure that the law operates in a way that is good for women, then we need to collect this data from patients. Thank you, Chair.
Amendment 273 to Clause 29 as on the amendment paper. The question is that that amendment be made. Lewis Atkinson.
Thank you, Chair. I'll just speak very briefly. I entirely agree with the points the Honourable Lady makes, and I would absolutely expect this information to be collected. I think my observation, as ever, would be I don't think we should be putting in primary legislation exactly whatever else. I think the powers are clearly there for the Secretary of State to specify which information to be that information should be collected. I'm struggling to find it, but I know the Honourable Lady, the sponsor, is moving an amendment regarding when the Secretary of State does make provisions, issue guidance under the bill, they must consult the EHRC and others in respect of protected characteristics, and I'm sure in doing so, did the Honourable...
Would you give me a
Yes, of course.
Sorry, I'm desperately trying to find the amendment number, which hopefully helps the Honourable Lady, and indeed my other friend. I think it's the Amendment 500, which looks at what will be recorded, and it covers such data as the Honourable Lady is referred to.
Thank you. So I agree, that absolutely we need the data to ensure that the operation of assisted dying, we understand how that operates in relation to different protected characteristics and geographical distribution, etc. But I'm not sure the way to do it is through this amendment. Thank you, Chair.
Nasha.
Thank you, Chair. I wasn't intending to speak to this, but I'm just trying to find the Honourable Member's Amendment 500. I just really can't find it.
500 to clause 21, we've passed it already.
Sorry?
It's been passed already, it was to clause 21.
Sorry. Thank you. And I just want to understand one of the things that so I think in responding to the honourable gentleman from Sunderland, I appreciate that we don't want to put too much detail on the bill, but can I just point out that actually some of the commitment we've made as a government, certainly in relation to collecting data, we need to go further, and the simple reason being our laws, when it comes to equality, are just not right when we look at other issues such as the gender pay gap, etc. And that would, this amendment, Chair, coming back to it, would strengthen our position to collect that data. And I think it's really, really important, because if we are to look at, if we are to be really serious about reviewing this Act potentially, or looking at the loopholes, or looking at which communities are taking up, and if we find, I mean, I know the data in other jurisdictions would say this is potentially people of affluent background, but equally the concerns that the Honourable Member has raised in her speech, and the points that she's made very powerfully, there is a risk from the evidence that we've heard from people like Dr. Jamila and others, especially with the fear amongst people. So I would really strongly support that amendment, but I will also go back and look at the EHRC issues that the Honourable Member for Spen Valley has raised, and I thank him for raising that point. But I'm happy to give you...
I think we're giving away. I'm just looking again at this. Would she agree that in order to keep that list of protected characteristics that we need to collect information about up to date, we need to have a level of flexibility, not in primary legislation? And would she comment, for example, on the fact that no information regarding sexuality or other protected characteristics are included in this? That people may...
I thank the Honourable Member, and actually he makes a really, really valid point, and I think there is a issue, and I think there is something, if we're really doing this right, then are we going to be looking at all the 6 characteristics, because that is important. So yeah, I think potentially I agree with him, but thank you, Chair, I just want to speak to that.
Daniel Francis.
Thank you, Chair. Likewise, it's a pleasure, of course, to serve under your chairship. Likewise, I wasn't intending to speak, but I do think there are 2 slightly different issues here. There is the issue about the Equality and Human Rights Commission, and clearly, prior to second reading, they did produce a briefing paper on some of these issues, which have been covered in the early amendment that's been passed. And clearly, again, they gave some oral evidence to us where they were really not happy with some aspects, not having the equality impact assessment, and some aspects of where the bill currently stands. And I hear what my honourable friend from Sunderland says, but in that briefing paper they produced, and of course I do appreciate what the Equality Act says, they didn't talk about sexuality, for instance, but they did talk about many of the aspects which are in the Honourable Member for Richmond Park's amendment. And one thing that stands with me, of course, is if you remember the evidence we received from Dan Scorer from NCAT in his oral evidence, he particularly talked about the experience from COVID. 5 times more likely to have a do not resuscitate order placed on you if you have a learning disability. And there's wide evidence of fact, which members here, particularly myself, was very well aware of before we sought that oral evidence, and some of the experiences from that. And again, we know some of the experiences from that, and I remember very well as a councillor around the experience of ethnic minority communities during that period. I used to represent a council ward with a high West African population in one part of the ward, and there were clear cultural issues about people's experiences with the health service during that period, and whether or not they wanted to have vaccine uptake. I used to have regular meetings as leader of opposition on my council at the time about the different uptake of health services between different communities that there were during that period. And what I would say is there is a valuable reason beyond my Honourable Friend from Spen Valley's amendment of engaging with the Equality and Human Rights Commission, of seeking to have this data, and for the actual Assisted Dying Commissioner to have this data. Because clearly, again, and I'll talk about this later on this evening, hopefully we'll get there, in Dan Scorer from MenCap's evidence, he clearly talked about what if things go wrong for people with certain protected characteristics, and at what stage do we review those, or review that. And I think, as the Honourable Member for Richmond Park has said, I think for some of these characteristics, or the characteristics rather, I'll correct myself, the characteristics which are in her amendment, it is vitally crucial. Those of us that have had concerns, have had legitimate concerns. I think people have heard long and hard about where I've come from on this. I'm not opposed, like other people in this room are, per se, to assisted dying, but people have come at this from a position of concern about coercion, particularly for women, and the position that I've come to long and hard about learning disability or people where there is a judgment about the level of mental capacity they have. And I think it's vitally important, therefore, and I will be supporting the Honourable Member for Richmond Park's amendment, that we try and capture this data, and it should be on the face of the bill.
Jack Abbott.
Thank you, Chair, and it's a pleasure to serve under you this evening. I wasn't planning to speak either, but I think this speaks to a number of things we've been talking about over the previous few weeks, and I would caveat it immediately by saying I think everyone in the room acknowledges that the sponsor of the bill has made it absolutely clear repeatedly that data collection is absolutely essential to what we are proposing here. And I'm very sympathetic to what my honourable friend Sunderland says about not necessarily needing to put everything on the face of the bill. But without sounding like a broken record, and I know I've made this point a number of times over the last few weeks, I do think it is critically important in certain situations that whilst there may be some regulations or inferences that exist which may lead to certain outcomes that we'd all like to see on this committee, I do not think there's anything necessarily wrong with explicitly putting this in writing. I think everybody has used different stats from different jurisdictions and in their own way to kind of lend weight to their arguments. What I would say is many of these stats, whilst they are relatively consistent in a number of areas, they're not necessarily decisive. I myself cited some stats yesterday for a particular amendment, which said around 10% of people using the assisted dying route had complications during their final stages. But again, as I said then, that was with an incredibly small sample size. That was just over 100 people. So I do think it is really important that if the bill is passed and we do go down this path, that it is critical that robust and quite expansive data gathering in a number of different areas is pursued. And I'm sure absolutely that any government would look to do so. But equally, as I say, whilst it doesn't create any loopholes or unintended consequences, I do think this sort of thing should be on the face of the bill, at the very least to provide reassurance that this sort of evidence gathering is certainly going to be happening if the bill is passed. Thank you.
Minister.
Thank you, Chair. I don't have a whole lot to add, simply to point out that as the bill stands, Clause 34 requires currently the Chief Medical Officer to, amongst other things, to submit an annual report to the relevant national authority on the operation of the Act. The sponsors' Amendment 382 would make the Voluntary Assisted Dying Commissioner responsible for this function instead. Amendment 274 would require that the report under Clause 34 contains an analysis of the additional information to be collected under new Clause 10 and Amendment 273. So I just remind the committee of that, because it's there's the discussion that everyone is having with regard to what sort of information should be gathered at what points in the process. There's then the reporting and monitoring coordinating function performed by the Voluntary Assisted Dying Commissioner, should those later amendments be passed.
I mean, my assumption is that once a commissioner is appointed, and in drawing up the regulations and the guidelines around reporting, there will be consultation between the government and the commissioner about what the commissioner actually wants to report on. And I assume from what she's saying is that unless we collect the data, he or she's got nothing to say in their report.
Minister.
Thank you for that intervention, and that's exactly why I just add that point, because one of the design features of the commissioner model is to have that monitoring function, which will undertake annual reporting and assessment of patterns in the practice should this legal regime come into force, and that's exactly what I would anticipate, and exactly how I would anticipate it working, that the Commission would say, well, you know, and also self-correcting, you know, we need to see more information on this because this is a concern. We've got this equalities data, we've got this whatever data we've collected. We need to see more on this because this pattern is a concern to us, or this would help illuminate how the practice is operating. That's all I wanted to rise to add, because one has to appreciate the operation of the regime as a whole.
Kim Ledbetter.
Thank you, Chair. As has been alluded to by, I think, various members of the committee, I fully supported the intention behind this amendment. But I think it will be covered, and I think I mentioned my Amendment 500, but actually probably more pertinently Amendment 455, which looks at the report that the Assisted Dying Commission would produce. This is the annual report, which makes reference to protected characteristics and sets out that under regulations any other such data can and should be collected. And I feel confident that that would encompass the points that are made by this amendment. I think it also makes reference to the analysis that's covered by 274. Yes, so I feel confident that the intention will be met by the introduction of the Voluntary Assisted Dying Commission, but I wholeheartedly agree that data collection is a really fundamental, important part of the process.
Sarah Olney.
Thank you, Chair. I just wanted to make a couple of further points in response to some of the points raised by other members. First thing, I looked at the Amendment 500 that the member for Spen Valley had directed me to, and thank you to the member for Reigate, whose record keeping is much better than mine, for showing it to me. I was going to say that it doesn't cover a lot of the areas that I've raised, but now that she's talked about 455, but I think it's important to say that only refers to protected characteristics under the Equality Act. I have specified these particular ones specifically in response to some of the evidence that we received. The person's age, in particular, that was a response to Together for Short Lives, who represent children's hospices, including Shooting Star in Richmond, and their specific concerns around the issue of assisted death being raised with young people under 18. That's why I specified that. Gender and ethnicity, I've mentioned in my earlier remarks, but that came through very, very strongly in a lot of the oral evidence that we received. To address the point of the member for Sunderland Central, I didn't hear at any point sexuality being raised as a risk factor. Obviously, members of the LGBTQ+ community do experience a great deal of discrimination, but I haven't heard it raised as a specific risk factor for assisted dying, which is why it's not on the list. The reason I put postcode, I don't know a better way of assessing somebody's whether someone is from a low-income background or not. And I would particularly draw the lead member's attention to this one, because that isn't a protected characteristic, obviously, under the Equality Act. But I remain really concerned. I've pointed to the evidence from... Happy to.
Just so that there is, for the avoidance of doubt, socioeconomic status should have been a protected characteristic under the Equality Act, were it not for the previous Conservative government.
Sarah Olney.
Well, that's a very useful intervention, thank you. It isn't currently, as I say, a protected characteristic under the Equality.
I think the Honourable Lady meant the previous Conservative and Liberal Democrat government, but just to be strictly accurate about
Clarification. Sarah Olney.
I expect she did, but since none of us in the room, I don't think, were actually members of that government, or indeed members of Parliament at the time, I don't know how you want me to respond to that. But it remains the case, I believe, that it is not currently a protected characteristic under the Equality Act, but if people want to reopen that, I'm sure there'll be an appetite to.
I'm grateful to the lady, and I mean, obviously she's a London member, but I would gently point out to her that particularly in a London context, actually postcode is a very poor indicator of socioeconomic status. Certainly I was a London Assembly member for 8 years, representing Central London, and in large parts of Central London there is social housing within the same postcode as there is extremely expensive houses running into the many millions. So the postcode indicator, I'm afraid, in certainly urban circumstances, is quite a poor indicator of socioeconomic status.
I thank the Honourable Gentleman for that intervention, and I know Barnes Ward in my constituency is one of the most unequal wards in the country. So I fully appreciate the point that he is making. As I say, for now, that's what I have in terms of a socio-economic indicator, thanks to the failings of our predecessors to include it in the Equality Act. What I would say is I'm open to amendments at report stage for anybody who has got something more compelling. I do think it really, really matters that we look at the socio-economic status of people who are seeking an assisted death, and I welcome feedback and, as I say, further amendments on how that particular part of the clause could be improved. I think a disability, obviously, that came up many, many times across the written and oral evidence. And so that is why I've specified these particular characteristics. It is in response to the evidence that we received, and that is why I am keen to press this to a vote. Thank you.
Amendment 273 to clause 29, as on the amendment paper. The question is that the amendment be made. As many of that opinion say aye. Aye. To the contrary, no. I think the ayes have it. We now come to amendment 446 to clause 29. In the name of Rachel Maskell, with which it be convenient to consider amendment 486 and clause 29 stand part. Thank you. Danny Kruger.
Thank you, Chair. I beg to move these clauses in the name of the member for York Central. Clause 29, as discussed, requires the Registrar General to prepare and lay before Parliament a report providing statistical analysis of deaths arising. And we've seen before, we've spoken before about the paucity of data from other jurisdictions and the problems arising when data is not collected from the start. For instance, Canada only collects data in relation to disability. When it's suddenly discontinued, as happened in Washington State, as I understand it, when it's insufficiently granular. So when you only get the headlines. So I think it is valuable, and I welcome the decision of the committee just now to support the amendment in the name of the Honourable Lady. These amendments would ensure that we could fix these problems from the start. So Amendment 446 would give the Secretary of State the power to specify the data sets which must be made available, and that these must be approved by Parliament. MPs would then be able to interrogate what data we are collecting and what questions it enables us to answer. Ensuring that this is determined by regulation places this in law and ensures ministerial responsibility and parliamentary oversight. Amendment 486 sets out the data that must be included, and this includes demographic information, including breakdowns by protected characteristics, and I acknowledge the conversation that's just been held on that topic, but also the length of time between the taking of the approved substances and the time of death. It feels to me, it strikes me that that is a very important consideration. I would hope that that would be specified in these regulations that the Registrar General would be providing, but it's not clear at the moment that that might be that would be included. And also that I think it's vital that any complications are properly not just recorded but reported. So thank you, Madam Chair. I don't propose to push these amendments to the vote. I think the argument has been sufficiently made. I'm grateful to the committee for supporting the previous amendment, but I wish it were otherwise, that we were specifying more clearly what data will be collected. I hope that perhaps this debate will encourage the Registrar General to ensure that the most comprehensive data is presented to Parliament.
Amendment 446 to clause 29 is on the amendment paper. The question is that this amendment be made. Minister.
Chair, I think in light of the honourable member's remarks, I don't think I have anything further to add, but obviously to note his remarks.
Kim Ledbetter. I've got nothing to add, Chair. Danny Kruger.
Withdraw.
Is everyone content for the amendment to be withdrawn?
Aye.
We now come to Amendment 486 to clause 29, with which it has already been debated with Amendment 446. Does any member wish to move the amendment formally? Amendment withdrawn. We now come to the question that clause 29 as amended stand part. The question is that clause 29 stand part of the bill. As many of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. We now come to Amendment 447 to clause 30 in the name of Rachel Maskell, with which it would be convenient to consider Amendments 394, 448, 534 and 523. I call now Shah to move Amendment 447.
Thank you, Chair. I'd like to move Amendment 447 in the name of a member for York Central, and I also want to speak in support of Amendment 523, tabled by the Honourable Member for East Wiltshire, which adds helpful clarity to the amendment I am moving. The bill, I also want to acknowledge that my understanding was the bill's sponsor indicated that this was something that I'm happy to give way for her to clarify.
I can confirm I'm very happy to support this amendment. Thank you, Chair.
Perfect, thank you. I like it when we get to amendments that are supported. The amendment was the amendment by the Honourable Member for York Central was literally to change the word may to must. And the first four matters that the bill lists are so important that issuing codes of practice cannot be left as just a choice for the Secretary of State, but it has to be something that the Secretary of State has to do. And it's worth pointing out when we say, I think for myself it's worth pointing out, because I'm learning about this new process, that when we're leaving it to the Secretary of State, that could be under any government, depending on how long it takes. So it's not necessarily just our government, it could be another government. Well, I'm just pointing that out. Just because somebody pointed it out to me very clearly. So I was like, okay, I was shocked by that detail, but hey. The bill sets out 5 areas of responsibility which the codes could cover. These 5 areas include some of the most consequential matter this committee has included. The first, for doctoral assessments of a person having a clear and settled intention to end their own life, whether that person has capacity to do so, accounting for depression and other mental disorders, effect on decision making, the treatment of palliative hospice or other available to the person, and provisions for effectively communicate this to them, the arrangements for providing approved substances to the person, and the assistance recipients may be given. Those topics are all vital, and I'm pleased that we now have an amendment which ensures that the Secretary of State does have to issue codes of conduct, and he or she must do that, but equally they may not. As in these matters, if these matters were not covered by codes of practice, they could be left to individual doctors to interpret, and that would mean doctors would face unfamiliar and complex decisions without the clear guidance that a code would give, which could have created, or indeed would have created dangers for both doctors and for people seeking assisted dying. The fifth area of responsibility covered by the bill is any of the matters the Secretary of State includes as appropriate. It seems to me clear the Amendment 447, because the Secretary of State will be issuing codes on practice of first four fields, but must also issue codes on other matters if they see a need for them, and I'm confident we all agree on that. Amendment 523 makes this extremely clear. That amendment makes it plain that the Secretary of State could issue codes of practice on any other matters that they see as appropriate. But the Secretary of State would not have to do so if they thought there were no other matters that needed such codes. And I believe that this is a very sensible clarification. It appears to me that it preserves what the bill drafters were doing when they originally wrote this clause. I would like to briefly return to Amendment 477. Actually, I won't return to it on that point simply because we've accepted this amendment. But if this bill passes, we will be authorising doctors to depart from centuries of previous practice. They will face decisions which they have not previously had to take. Given that, I am pleased that the government now will be, if this bill passes, get the opportunity to set down the clearest possible guidelines for medical professionals to follow. And there are many of them in this clause. Doctors in England and Wales have never previously had to assess someone has a clear and settled intention, and it is surely unfair to ask the doctors to face this question to work out how to make that judgment without giving them clear guidance from a code of practice. It also mitigates the risk that different doctors will approach this task in widely differing ways. It is, the truth is, Chair, it is untested, all of these things are untested when it comes to the Mental Capacity Act for assisted death, where the person will take lethal drugs to end their life. They are important and difficult questions of interpretation that will be addressed by codes of practice again. This will give us much needed clarity. And the same is true of a provision of palliative care to people considering assisted dying and how doctors advise them. The Independent Palliative and End of Life Care Commission found that has found that palliative care amongst doctors, the knowledge about palliative care amongst doctors is often limited. So these Secretary of State's intervention will be much appreciated to be able to give some clearly settled direction through these codes. So I'm grateful that the Honourable Member has accepted this amendment, and I look forward to working for the rest of his bill to get some more amendments passed.
Amendment 447 to clause 30. As on the amendment paper, the question is that the amendment be made. Daniel Francis.
Thank you, Madam Chair, and I intend to speak to move Amendment 394 in my name, which is the amendment to clause 30 and part B on the Secretary of State's Code of Practice, to add the words the provision of information and support to persons with learning disabilities who are eligible to request assistance to end their own life under this Act, including the role of advocates for such persons. I am, of course, aware that my honourable friend has amendments 517 and clause 25, which we'll be discussing shortly as well. What I would say, I did some time ago table a number of amendments, one of which was accepted, including this one, following conversation with MenCap, and I just will recall the oral evidence that Dan Storer from MenCap gave us, which was regarding advocacy support and around the discussions and about the role of families, and he said individuals should be able to choose who supports them with those discussions, whether it's friends or family members or an independent advocate. and that would probably be Mencap's preference. That there's an advocate who's specifically trained to support people with a learning disability who are considering their end-of-life options. I won't go on at great length. I think members have heard my views on this matter throughout the committee about the role of support for people with learning disabilities. I will, I'm conscious to say there are further amendments on this matter later on during this clause, but I will be moving this amendment when we get to that stage in a consistent manner with the approach I've taken throughout the committee. Thank you, Chair.
Jack Abbott.
Thank you very much. I realise we could be called away any moment to vote, but just to make progress to this, it's a relatively small amendment, and I do appreciate that it does, to an extent, already feature in the regulations, but it's to ensure that it's also put in the code of practice as well. And I think it's important to say that anybody seeking assisted death under this bill who meets the eligibility criteria should be able to do so. However, there is a risk that requirements that patients provide two forms of proof of ID could present challenges for certain groups, causing inequalities of access. Now, we all know that... I think we're just about to... Shall I stop there, Chair? Carry on, carry on. No, there we go.
The committee is suspended for 15 minutes due to a division in the chamber. The committee will reconvene at 7:15. And we will resume where we left off with Jack Abbott.
Thank you very much, Chair. Thank you. As we're into the late session, we all know that inequitable access to good quality health and palliative care is a massive issue across the country, and that certain groups of communities, for example, those living in areas of high deprivation and those from Black, Asian and minority ethnic communities, and indeed those from inclusion health groups such as the homeless, already experience significant challenges in accessing quality care. We have a duty to ensure that anyone meeting the eligibility criteria who wishes to seek an assisted death under this bill is able to do so. We must therefore ensure that the requirements for which forms of proof of identity are acceptable do not exacerbate existing inequalities of access and prevent those who would otherwise meet the eligibility criteria from seeking an assisted death should they choose to. The question of which forms of proof of identity are acceptable is therefore essential, as we know that photo ID requirements can present additional barriers to certain demographics and communities. Data from the Electoral Commission following the 2023 local elections found that while only 3% of all non-voters said that they did not vote because they did not have the required ID, this was 8% for unemployed non-voters and 9% for disabled non-voters who report as being limited a lot by their disability or health condition. The data also found that awareness of ID requirements were also lower among those without an accepted form of ID at only 74%, in contrast to 92% of the population overall. Awareness of this requirement was also lower amongst young people and those from Black, ethnic and minority communities. Clearly, a photo ID requirement could present barriers to equitable access to assisted dying. We must ensure that requirements for which forms of identity are acceptable do not create new inequalities of access. However, the requirement for proof of identity has been included in this bill for a very good reason. It is a necessity and a critically important safeguard, and ensuring the bill has requisite safeguards for assisted dying to be safely implemented is central to what this committee is doing. Therefore, it's important we get the question of what forms of proof of identity are acceptable for someone to access assisted dying under this bill, and we must also ensure equity of access to the service and without diluting critical safeguards. In the bill as it currently stands, Section 6 states that the regulation regarding the forms of proof of identity of which are acceptable are subject to a negative procedure. This issue is too important to be left to negative procedure and without sufficient parliamentary scrutiny. This amendment would therefore, by including the requirements for which forms of proof of identity are acceptable into Section 30, rectify this. The amendment would entail that regulations pertaining to which forms of proof of identity are acceptable under Section 6 are subject to the affirmative procedure, and that prior to that, the Secretary of State issuing a code of practice in relation to the question, and they would have to consult such persons as the Secretary of State considers appropriate. So by approving this amendment, we would guarantee that the question of which forms of proof of identity are acceptable is given the requisite consideration to ensure that requirements do not act as a barrier to equitable access to assisted dying without diluting the safeguards which the requirement inserts into the bill. Thank you.
Danny Kruger.
I'm grateful. I just wanted to thank you, Chair. I just wanted to quickly explain that my Amendment 523 is consequential on Amendment 447. If this is a drafting issue, I won't go into the detail of it. It might be that 447 is... if 447 is made, as I understand it will be, then 523 is not necessary. And I would be grateful for the Minister's guidance if she's advised by Parliamentary Council that the clause as amended is okay and no need for 523, then I don't propose to press it, but I will take her guidance on that. Thank you.
Minister.
Thank you very much, Chair. This group of amendments relate to Clause 30 of the Bill and the codes of practice that may be issued by the Secretary of State. Turning to Amendment 447, as the Bill is drafted, the Secretary of State may issue one or more codes of practice in connection with arrangements pertinent to the assisted dying process. Amendment 447 requires the Secretary of State to issue such codes. It substitutes the word must for may. As such, codes of practice would need to be issued for all matters listed in Clause 30, subsection 1. Amendment 394 has the effect of broadening the Secretary of State's power to issue codes of practice. It explicitly enables the Secretary of State to issue guidance in connection with information and support to persons with learning disabilities who are eligible to request assistance under the Bill. This includes information and support about the role of advocates. I would note that under the Equality Act 2010, health providers are already under a duty to make reasonable adjustments to the provision of services, including for persons with a learning disability. This duty includes taking steps to provide information, including on what support services are available. 448. Chair, as drafted, clause 31C provides that the Secretary of State may issue codes of practice on arrangements for effective communication in connection with the provision of assistance, including the use of interpreters. 448 provides that if the Secretary of State issues codes of practice which include the use of interpreters, those interpreters should be registered and qualified interpreters. This amendment would limit those who are able to translate to only those who are registered and have a recognised qualification. The amendment does not state who or what such a registration should be with, or what would constitute a recognised and appropriate level of qualification. 534 adds to the list of codes of practice which the Secretary of State may issue. The addition is a code of practice about the acceptable forms of proof of identity when a person makes a first declaration. Clause 6.3 of the bill already provides a regulation-making power that sets out the acceptable forms of proof of identity. Amendment 534 would give the Secretary of State a power to make codes of practice about how someone can ensure they are compliant with the requirements set out under Regulation 6.3. The amendment has little practical effect because 31E already provides a wide power for issuing codes of practice. It provides that the Secretary of State may issue codes of practice on such other matters relating to the operation of this Act as the Secretary of State considers appropriate. 523 allows the Secretary of State to issue further codes of practice at his discretion, should they not be covered by the preceding subsection 1 under this clause. I note the Honourable Gentleman's question about whether we are, as the sponsor has said, that she is minded to support 447, and the Honourable Gentleman for East Wiltshire is asking whether, if 447 is incorporated into the bill, does that render 523 unnecessary or surplus to requirements? I'm not entirely sure. If I could just check, perhaps I'll quickly check whilst the sponsor of the bill is making her remarks, and I will just check on his question and come back to him immediately.
Kim Ledbetter.
Thank you, Chair. I thought we were going to get a full house with this lot, but anyway, let's have a look. I'm minded to support Amendment 447, as I previously said, and I'll wait to hear from the Minister the impact that that has on 523.
Will the Honourable Lady?
I will give way.
I thank her for giving way, and I can confirm that 523 is a helpful amendment as 447 is incorporated, and so that is all fine. So we're good with that.
Very helpful indeed. So then I'm very pleased to support Amendment 523 in the name of the Honourable Member for East Wiltshire as well. I'm also minded to support the Amendment 394 in the name of the Honourable Member for Bexley and Crayford. I think it's very sensible, as his other amendments which I've supported have been. And in terms of 534 for the Honourable Member from Ipswich, again, I'm not sure it's entirely necessary, but I fully understand the sentiment, and therefore I am minded to support that amendment as well. That's 4, isn't it? Yeah, which brings me on to the final amendment, 448. I wanted to support this amendment, but I've taken on board the comments of the Minister around the lack of clarity around what it means to be registered and qualified, and I think as such, I can't support that this evening, but I think we could maybe look at coming up with something for report stage which would achieve the objective that the member for York Central has intended. And those are my closing remarks. Thank you, Chair.
Nasha. Amendment 447 to clause 30 as on the amendment paper. The question is that the amendment be made. As many of their opinion say aye. Aye. To the contrary, no. I think the ayes have it. The ayes have it. We now come to Amendment 394 to clause 30, which has already been debated with Amendment 447. Does any member wish to move the amendment?
I'd like to move, Chair.
Amendment 394 to clause 30 as on the amendment paper. The question is that the amendment be made. As many of their opinion say aye. Aye. On the contrary, no. I think the ayes have it. We now come to Amendment 416 to Clause 30, which has already been debated with Amendment 414. Jack Abbott, do you wish to move the amendment formally?
Yes, Chair.
Sorry?
Yes, I do, Chair. Sorry.
Amendment 416 to Clause 30, as on the amendment paper. The question is that the amendment be made. As many of their opinions say aye.
Aye.
On the contrary, no. I think the ayes have it. We now come to Amendment 448 to Clause 30, which has already been debated with Amendment 447. Does any member wish to move the amendment formally? Skip it. We now come to Amendment 430 to Clause 30, which has already been debated with Amendment 435. Daniel Francis, do you wish to move the amendment formally? Amendment 430 to Clause 430 to Clause 30, as on the amendment paper. The question is that the amendment be made. Does many of their opinions say aye? Aye. On the contrary, no. I think the ayes have it. We now come to Amendment 517 to Clause 30 in the name of Dr. Marie Tidbull, of which it will be convenient to consider Clause 25. Marie Tidbull.
Thank you, Chair. It is a pleasure to serve under your chairship. I rise to speak to and to move new Clause 25 and my related Amendment 517. I also wanted to note my pleasure in seeing that Amendment 447 has gone through, mandating the need for the Codes of Practice, and did indeed also support the Honourable Member for Bexley-Heath's and Crayford's Amendment 394. My new Clause 25 would require the Secretary of State to, by regulations, make provision for independent advocates to provide assistance to qualifying persons under this bill. Amendment 517, which would add arrangements for a qualifying person to receive the support of an independent advocate to the list of matters that Codes of Practice in Clause 30 may be issued upon. This is deeply important to me. In my speech at the second reading, I said so often, control is taken away from disabled people in all sorts of circumstances. In order to ensure that there is compassionate choice at the end of life, it is right that the bill is tightly drawn around the final stages of terminal illness for adults and includes the strongest possible safeguards. Those safeguards must include strengthening the voices of disabled people, both within the bill and in monitoring its impact on disabled people if the bill is ultimately passed by Parliament. I have also tabled this new clause and related amendments along with my amendment in new Clause 27 for a Disability Programme Board to strengthen disabled people's voices and empower disabled people to be better enabled to be treated with dignity and respect where they are a qualifying person who is seeking to understand options around end-of-life care. Subsection 3 makes it clear that new Clause 25 provides for the role of independent advocates to provide support and advocacy to a qualifying person who is seeking to understand options around end-of-life care, including the possibility of requesting assistance to end their own life to enable them to effectively understand and engage with all the provisions of this bill. During our oral evidence sessions, I asked Professor Tom Shakespeare, the leading disability scholar and public policy expert, what measures in the bill could be strengthened to further protect disabled people, and he said, we could have more of an advocate for the person who is requesting assisted dying, somebody who will support them within the law to make that decision or to think about their decision. My new clause responds to the evidence we saw in the oral witness sessions and augments some of the earlier proposals made by the Honourable Member for Bexley-Heath and Crayford. It extends those earlier proposals in two ways. First, under my amendments, the qualifying person includes those who have a learning disability, autism, and, importantly, those who have a mental disorder under Section 1 of the Mental Health Act 1983. It also extends its scope to cover those who, as set out in subsection 4b, may experience substantial difficulty in understanding the processes or information relevant to those processes or communicating their views, wishes or feelings, or that may meet the criteria that the Secretary of State may specify by regulations. Second, it sets out in more detail the establishment of an independent advocacy role. In subsection 2 in particular, it makes provision for payments to be made to or in relation to persons carrying out the function of an independent advocate under this section, training that such advocates must undertake before being appointed, and obligations on those persons performing these functions under the Act, if it's passed by Parliament, to ensure the presence of an independent advocate for a qualifying person. I am very grateful for MENCAP's feedback on my amendments and that of Yogi Amin, who has decades of experience working as a court protection, mental capacity and equality lawyer. During the committee's oral session, Dan Scorer from MENCAP talked about the need to ensure that rights to advocacy begin at the very start of the process, including the initial conversation with the medical practitioner to enable people with a learning disability who were terminally ill to be fully prepared and supported for that discussion. He emphasised the importance of preparing and supporting people for such discussions, such that MENCAP wanted to see a right to advocacy included within the bill to support people considering their end-of-life options. I have worked to ensure that my amendment inserts a strong model of independent advocacy within the bill. And crucially, as I've mentioned already, this is reinforced by subsection 2E, which states that such advocates must undertake training before their appointment. Read in conjunction with Amendment 394, brought by the Honourable Member for Bexley Heath and Crayford, my amendments on independent advocacy help to integrate a vehicle into this bill to ensure the use of the NHS Accessible Information Standard about rights to information and support for disabled patients within the bill for qualifying people, helping to fulfil one of the other important requests raised by MENCAP in their evidence. For these reasons, I recommend this new Clause 25 and Amendment 517 to the committee.
Amendment 517 to Clause 30, as on the amendment paper. The question is that the amendment be made. Daniel Francis.
Thank you, Madam Chair, and I think we're in danger of having much consensus this evening. So, you know, like the member for my honourable friend for Penistone Stockbridge, I think members know this is an issue which is very, very close to my heart, and she knows more than anybody how ingrained, unfortunately, inequality for disabled people in this country remains, and that's something that, again, I see and know firsthand as the parent of someone with a very complex set of disabilities, including a learning disability. I welcome the amendment in the name of my honourable friend from Penistone Stockbridge, and we know that my concern with the bill has been giving protections to vulnerable people, particularly those with learning disabilities, and this amendment was address some of those concerns by providing an independent advocate, as MENCAP asked for in circumstances that the Secretary of State would specify. And I welcome the amendment would join, as my honourable friend has said, with my amendment 394 in supporting those measures. It includes people who have substantial difficulty in understanding the process or information involved or in communication. And I'd like to note that the specified conditions could include a wide range of people, and I thank my honourable friend for including that range of people. It's crucial, of course, to see in due course what circumstance or conditions will be decided by regulation, but I think, as I've said to my honourable friend, there are two things that I've said throughout the course of this debate, and they remain a tension really within this, that I've had the one issue about supporting people with learning disability and the one issue about capacity, and as I've said to my honourable friend, I think we just need to be very clear in the training, and I trust that that will come out in due course, that advocates aren't seen, because they could under the Mental Capacity Act, as leading people into decision making. And I think we just need to be very clear in the training, because the Mental Capacity Act would allow them that scope, because they would still, as in any other decision making, have to assist someone in making that decision. But I'm confident, and I will be supporting this, that in that training we can overcome that. I will just say that in her written evidence, Patricia Cook talked about, in TIAB 325, talked about a decision making for her daughter who has Down syndrome. And she said, my daughter has the mental capacity to make decisions about her daily routine, social, educational, family matters, but she lacks the capacity to manage other aspects of her life, such as her financial affairs and healthcare. She went on to say, my daughter is much more likely to defer to a clinician's proposal, as she might think that she ought to agree. And that again was an important point that we heard in our oral evidence. And I would hope that an advocate would be in the position to provide support and advocacy to a person having to make that decision.
Will he give way?
Absolutely.
Thank you. And I take on board his point and appreciate it, and hope he would agree with me that subsection 3, which emphasises the purpose of this amendment, which is that it should apply across the spectrum of access to seeking assistance, to enable people to effectively understand and engage with all of the provisions under the Act. And I very much wanted to ensure that it would apply and be accessible at every stage.
No, again, I welcome that. My honourable friend knows, what my concerns, but she knows that I will be supporting this amendment this evening. So, what I would say is advocates must have an understanding of the end-of-life options available and be able to communicate this clearly and to explain to patients about the medical treatments available, palliative care, social care and assisted death. And that's quite complex. As I've said previously, my own experience of mental capacity is, for my daughter, she would never have the level of capacity to be able to make this decision. But I, on a daily basis, did this morning, have to explain in a very 2 or 3 point decision-making process about the decisions that are there in front of someone. And so I think it's vital that advocates are there, that they have that training. And of course, for many people, like my daughter, who is almost blind as well as being learning disabled, there are those additional communication skills when you have those extra sensory difficulties. So it's vital for people like Mrs Cook's daughter, who may be vulnerable to influence, and that the advocate must be able to explain all the options clearly without pressurising the person down one route. I believe the amendment will provide important support to those with less capacity or difficulty in understanding all the options in front of them. As I've said, my 2 things that I've banged on consistently in this process have been about learning disability and mental capacity. There has been that conflict for me, even in this amendment, but I'm confident and I know my honourable friend's amendment comes from a very good place. What I would say, of course, and we'll come to this next week, is that I, like my honourable friend, have listened to MENCAP's evidence, but MENCAP's evidence did also talk about reviewing the bill at an earlier stage in the process and currently envisaged, and that's why amendments 493, 494 and 495 are in my name for next week, because I've consistently listened to MENCAP's evidence. But my view is, if this does become law, that the system would work well if these regulations are implemented correctly. I will be supporting the amendment from my honourable friends from Penistone and Stockbridge. I thank her for bringing this forward. And I do know that my honourable friend from Spen Valley also has listened hard on this during the process, and I'm grateful. I think this will have a degree of unanimity this evening, and that we can bring this forward. Thank you, Chair.
Danny Kruger.
Very grateful, Madam Chair, and can I pay tribute to the Honourable Lady for the amendments that she's tabled, and indeed to the work that she's been doing on our committee. I do regret her victory over my friend who was the MP for Penistone and Stockbridge, but she's bringing a lot to the to Parliament and to this committee, and so I have to follow the honourable gentleman in supporting these amendments. I did want to ask her though, and I don't know whether she's in a position to respond with a further speech or intervening. I do have some concerns about the operation of the amendments. I recognise that the role of the independent advocate exists in our system already, very, very usefully, very importantly that it does, and therefore I see the value of it and the appropriateness of it for an assisted dying regime. But we will be introducing, if these amendments are accepted, this role of the independent advocate with the sombre recognition that it is necessary in consequence of a bill which will allow doctors to discuss ending the patient's life as an option with anybody, no matter how well or ill-equipped that person may be to handle such a conversation on their own. and no matter how old they are, indeed whether they're even 18 years old. So I support the amendment, but I do so in recognition of the very significant dangers that I think this bill represents to it, all potential applicants. And I want to ask the Honourable Lady, or perhaps the Minister or the sponsor, whether they feel that the amendments go to the heart of the concerns that have been raised by the Honourable Member for Bexley Heath and Crayford. I'm pleased to hear that he is satisfied to support this amendment, although I do echo some of the suggestions of concern that he just made. The new clause makes clear that the advocate is there to support the person, to provide support if the person, I quote, is seeking to understand options around end-of-life care, including the possibility of requesting assistance to end their own life. And Amendment 517 addresses the need for a code of practice when a qualifying person is requesting assistance to end their own life. So my question is whether the clauses and the new clause in the amendments fully cater for a situation in which that individual is not requesting assistance to end their own life, when they are not seeking to explore this particular option, given that we have retained the right of medical professionals to raise the possibility of assisted dying unprompted with patients. I am concerned that, as I think the Honourable Gentleman implied, there might be a concern if, in fact, the medical professional initiates the conversation, or indeed whether the advocate themselves is supportive of assisted dying and whether deliberately or inadvertently has the effect of encouraging the applicant to consider that option or the patient to consider that option. And indeed, as the Honourable Lady, I think, said in her intervention on the Honourable Gentleman, the new clause creates the role of independent advocate to provide support to help them to effectively understand and engage with all the provisions of this Act. It doesn't specify that they should be obliged or indeed equipped or experienced in supporting the patient to engage with other options.
Will you give way?
Happy to give way.
Thank you, Chair. First of all, I would say to him that it is necessary that they are able to engage with all the provisions under this Act. The reasons I didn't support my honourable friend's previous amendments was because I felt that they would have only provided advocacy at too late a stage and would not effectively support them at that point that he talks about in Clause 4, around that moment of seeking assistance. So I hope that answers his question.
I'm grateful to her, and I recognise that that's very helpful, because indeed that is my concern, that we need to ensure that there is all necessary support for the patient at the earliest stage possible. Happy to give way.
Thank you. I would also add that the subsection 2E on training is central to this amendment and will also assist with that respect. And if the Chair will permit, this is why I talked about new clause 27, because I have built in a strong structure which can reflect on how these things operate.
The member will have an opportunity to speak at the end of this amendment. Danny Kruger.
Well, that's great. Thank you, Chair, and thank the Honourable Lady. I worry a little about the magic powers of the training fairy that we are invoking frequently in this bill to resolve all these anxieties and putting the resolution of difficult tensions onto future professionals and imagining that through training we can resolve all these difficult challenges. But given the absolute obvious value of having an independent advocate for the people who need that role in the process, and given the Honourable Lady's assertion that it's important that role is fulfilled at the earliest stage possible, which I entirely agree with, I'm very happy to support the amendment.
Minister.
Thank you, Chair. Amendment 517 relates to new clause 25, which I'll come on to next. Amendment 517 makes provision for the Secretary of State to issue a code of practice regarding arrangements for a qualifying person to receive the support of an independent advocate as set out under new clause 25. New Clause 25 would require the Secretary of State to make regulations about the appointment of independent advocates. The role of the independent advocate would be to provide support and advocacy to a qualifying person seeking to understand options around end-of-life care, including the possibility of requesting access to assisted dying. A qualifying person is defined in the new clause as someone who has a learning disability, a mental disorder as defined by the Mental Health Act 1983, or autism, or who might experience substantial difficulty in understanding the processes or communicating their views, wishes or feelings, or who meets criteria specified by the Secretary of State in regulations. While the new clause requires the Secretary of State to make regulations about the appointment of independent advocates, there is discretion as to what those regulations should include. The clause sets out a non-exhaustive list of the things that the regulations may provide. The effect of this is that the clause leaves open who would be obliged to ensure an independent advocate is present and the precise nature of the obligations around their appointment. It is also unclear how a person would be determined to be a qualifying person, as the definition is quite broad and encompasses a wide range of people with varying support and advocacy needs. Finally, while the proposed new clause enables provisions to be made about payments of independent advocates, it's not clear who would make these payments or how they would be funded. I hope those observations were helpful to the committee.
Kim Ledbetter.
Thank you, Chair. My older friend, the member for Penistone and Stocksbridge, has made a really powerful and passionate case for the provision of independent advocates, and as always, has done an outstanding job of advocating for people with disabilities, including learning disabilities, mental disorders and autism, as she has done throughout this entire process. It's essential that anybody considering the choice at the end of life made possible by this bill should fully understand the nature and consequences of any decision they may make. And it's made me reflect, Chair, on, I think it was comments from the member for East Wiltshire a few weeks ago now, about the purpose of this bill. And he proposed that this bill is either about choice and autonomy or it's about safeguards. And actually, this is very clear evidence that it is and it must be about both. And I hope he can support these amendments tonight. I take on board the Minister's comments there, and I got an element of caution from him, but I'm very happy to work with the government and the member who's put the amendments forward if any further requirements are needed prior to report stage. But I am very happy to support these amendments and the new clause tonight.
Dr Marie Tidbon. Thank you, Chair. I'm very grateful to the support of the Honourable Member from Spen Valley, as well as the Honourable Member for Bexley, Heath and Crayford. And it sounds that I may also have the support of the Honourable Member for East Wiltshire, which also makes me very happy at this stage of the evening. I set out these amendments because I passionately believe in inclusive healthcare for disabled people and removing barriers to such healthcare where possible, but also ensuring that they have a strong voice in advocating for themselves and the healthcare that they need or desire. I, as I mentioned, have tried to write this amendment and the new clause to ensure that the access to the function of an independent advocate operates across the functions of this bill. I also have been keen to ensure that this is in conjunction with new clause 27, which I will be speaking about at a later stage, but hope, as I said in response earlier to the Honourable Member for East Wiltshire, that will provide a solid and robust opportunity to monitor the impact of this bill, if it were to pass through Parliament, on disabled people in its implementation in practice. So taken together, they create a solid foundation to both provide and enable disabled people to have a voice, but also a strong structure for accountability within the bill. I acknowledge the Minister's comments, and of course we'll work with the Honourable Member for Spen Valley and him to ensure that it is watertight.
Amendment 517 to clause 30 as on the amendment paper. The question is that the amendment be made. As many of their opinions say aye. Aye. To the contrary, no. I think the ayes have it. The ayes have it. We now come to Amendment 534 to clause 30, which has already been debated with Amendment 447. Jack Abish, do you wish to move the amendment formally? Amendment 534 to clause 30 as on the amendment paper. The question is that the amendment be made. As many of that opinion say aye. Aye. On the contrary, no. I think the ayes have it. The ayes have it. We now come to Amendment 523 to clause 30, which has already been debated with Amendment 447. Danny Kruger, do you wish to move the amendment formally?
Is that 523?
523.
Yes, I beg to move.
Amendment 523 to clause 30 as on the amendment paper. The question is that the amendment be made. As many of that opinion say aye. Aye. On the contrary, no. I think the ayes have it. That one. We now come to Amendment 417 to clause 30, which has already been debated with Amendment 414. Jack Abbott, do you wish to move the amendment formally? Amendment 417 to clause 30 as on the amendment paper. The question is that the amendment be made. As many of that opinion say aye. Aye. On the contrary, no. I think the ayes have it. The ayes have it. We now come to Amendment 216 to clause 30, which has already been debated with Amendment 187. I call Kim Ledbetter to move the amendment formally.
Move formally, Chair.
Amendment 216 to clause 30, as on the amendment paper. The question is that the amendment be made. As many of that opinion say aye. Aye. On the contrary, no. I think the ayes have it. We now come to Amendment 217 to clause 30, which has already been debated with Amendment 187. I call Kim Ledbetter to move the amendment formally.
Move formally, Chair.
Amendment 217 to clause 30 as on the amendment paper. The question is that the amendment be made. As many of that opinion say aye. Aye. To the contrary, no. I think the ayes have it. We now come to Amendment 523 to clause 30 in the name of Danny Kruger. 524 in the name of Danny Kruger, which would be convenient to consider clause 30 stand part. I call Danny Kruger to move amendment 524.
Thank you, Chair. Before I move 524, might it be appropriate whether I should do this as a point of order or not, but to correct the record from an earlier debate. I don't know if this is the moment to do that, but I wish to correct the record based on a mistake that I made earlier in the day's debate. Yeah, okay, I'm grateful, and this is the last speech I'm going to be making today, so I think this is the opportunity. I said earlier in debate that I cited evidence that there had been an exodus of care workers from the Australian care system, and members challenged me on this, I think fairly, because I've been looking since. I couldn't find the evidence that was in my mind. I think I was confusing it with evidence we did have about the numbers of palliative care professionals who said they would not want to work in the sector if assisted dying were performed by their organisations. The only evidence I've got from Australia is from Robert Clark, who was the Attorney General, who did cite on his own evidence rather than referring to statistics how many professionals are leaving the Victorian hospital system in consequence of the introduction of voluntary assisted dying there. But I thought I had evidence of statistical evidence showing the exodus. I didn't, so I correct the record and I apologise to the committee. I wish to move the amendment in my name and to speak to this clause. I'm very glad that the amendment would specify that individuals should comply with the codes of practices which have been issued by the Secretary of State. I'm very glad that the member for Spen Valley agreed to accept the earlier amendment requiring the Secretary of State to issue codes of practice, which is a very helpful step, but it's not quite sufficient because it does not address a critical weakness in the bill. And time and again we've been told that amendments that have been tabled were not suited to the face of the bill and that we should rely on codes of practice and guidance which will be issued subsequently. But now we are here and it is clear that under Section 30, subsection 6, the Code of Practice is something that those, I quote, performing any function under this Act must simply have regard to. Now, we've been told by the Minister repeatedly that the government's preference is to leave things to later, not to address issues on the face of the bill, that adding additional words, phrases and amendments would increase risk and be counterproductive. It's an argument we've heard from the front bench opposite repeatedly, and other members have dismissed suggestions for amendments to strengthen the safeguards as embroidery. It's been suggested that the more we write, the less safe the bill will be. I don't think these arguments will survive the other place if this bill arrives there. I think there is a vast difference between something on the face of the bill which must be complied with because it is in legislation, and something that those providing assistance under this Act must only have regard to. It is perplexing to me that the bill does not specify that practitioners should I quote, follow or act in accordance with the guidance, that isn't clearly specified. And these words matter. The Office of Parliamentary Counsel explores the choice of these different phrases in its guidance on common legislative problems. That guidance, by the way, was produced by the drafter of this bill, the former First Parliamentary Counsel, Elizabeth Gardner. So it's quite a deliberate policy choice to leave compliance with these codes of practice to the discretion of the individuals rather than to require it. The guide to making legislation, the Cabinet Office Manual, which the drafter will have been very familiar with, states that a code of practice is an authoritative statement of practice to be followed in some field. It typically differs from legislation in that it offers guidance rather than imposing requirements. Its prescriptions are not hard and fast rules, but guidelines which may allow considerable latitude in their practical application and may be departed from in appropriate circumstances. The provisions of a code are not directly enforceable by legal proceedings. And again, codes of practice are not to be used to define specific legal obligations. Where specific legal obligations are to be imposed, breach of which leads directly to criminal or civil liability, their content should be spelled out in primary or secondary legislation. A code of practice is not appropriate for this purpose, either to delineate the main obligation or to provide for exceptions or defences. So, Madam Chair, I don't think it's appropriate that so much is being left to ministerial discretion. And I do find it perplexing when I'm told how much, not to make a party political point, but we know how much Labour MPs distrust Conservatives, and yet they are willing, seemingly, as indeed, I suppose, Conservative colleagues in support of this.
Keep to the point, please.
Well, Madam Chair...
We keep to the point.
OK, the point I'm making is that we are suggesting that some future Secretary of State in another different government, of which we know nothing, might decide to issue codes of practice which will determine how this process is actually delivered. But I'll leave that point. Here we are. I think we must address the weak status of these codes of practice. I regret that they're being left in this weak form. But at a minimum level, we should be required that they are properly complied with. I'll finish with this. This cannot be remedied after the bill has passed, no matter how strong the language in the codes of practice. That language cannot override or change the nature of a statutory duty. Any enhanced duty has to come from a source that is external to the document being considered itself, namely the statute. So I simply ask the Honourable Lady, the sponsor of the bill, why does she not wish practitioners to comply? Why does she not insist that practitioners comply with the relevant provisions of the code?
Amendment 5 to 4 to clause 30 as on the amendment paper. The question is that the amendment be made. Minister.
Thank you very much, Chair. This is Amendment 524 as set out by the Honourable Gentleman for East Wiltshire. As the bill currently stands, a person is required to have regard to any codes of practice issued by the Secretary of State when performing a function under the bill. Amendment 524 would mean that individuals are instead required to comply with the codes of practice issued. This could limit someone to only doing what is specified in the code, rather than allowing them to exercise their professional discretion to perform the function in the most appropriate way, having given regard to the code. It is also unclear who would monitor or enforce compliance with the codes. Codes of practice are normally detailed practical guidance on how to comply with legal obligations and are generally not legally binding. I hope those observations were helpful to the committee.
Jim Ledbetter.
Thank you, Chair. I understand the sentiment behind the amendment from the member for East Wiltshire, but I think, as the Minister has just said, the codes of practice serve a particular purpose. Clearly, everyone has to comply and abide by the law, but codes of practice are there to assist in the exercise of a person's professional judgment, and I do worry about losing the ability for professionally trained and regulated people to use their professional discretion and to have the flexibility that they need to do their jobs well. And I think he answered his own question in his description of what a code of practice does. So whilst I think this is coming from a good place, It isn't something I can support tonight. I think we do need to have flexibility and trust in our professionals to do their job.
Danny Kruger.
Thanks. Chair, beg to move formally.
Amendment 524 to clause 30 as on the amendment paper. The question is that the amendment be made. As many of that opinion say aye.
Aye.
To the contrary, no.
No.
Division.
Vision room test.
Lock the doors.
Jack Abbott.
Aye.
Lewis Atkinson.
No.
Bambas Charalambas.
No.
Daniel Francis.
Aye.
Tom Gordon.
No.
Sarah Green.
No.
Rachel Hopkins.
No.
Surgeon Joseph.
Aye.
Stephen Kinnock.
No.
Danny Kruger.
Aye.
Kim Leadbeater.
No.
Kit Malthouse.
No.
Sarah Olney.
Aye.
Dr. Simon Ofer. Not here. Rebecca Paul.
No.
Jake Richards.
No.
Sarah Sackman.
No.
Naz Shah.
Aye.
Dr. Neil Shastri Hurst.
No.
Dr. Marie Tidball.
No.
And Sean Woodcock.
Aye.
The ayes are 7, the noes 13. The noes have it, the noes have it. We now come to the question that clause 30 as amended stand part. The question is that clause 30 stand part of the bill. As many of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. We now come to amendment 395 to clause 31 in the name of Daniel Francis, with which it will be convenient to consider amendment 396 and clause 31 stand part. I call Daniel Francis to move amendment 395.
Thank you, Chair. There are amendments 395 and 396 in my name. Carrying on the debate we had on the previous clause, again, these refer to the oral evidence we received from NCAP, and these, in the guidance from the Chief Medical Officer, would add clauses to ensure that persons consulted include persons with learning disabilities. I don't intend to go any further, Chair. I therefore beg to move the two amendments in my name.
Amendment 395 to clause 31 as on the amendment paper. The question is that the amendment be made. Minister.
Thank you very much, Chair. As the bill stands, clause 31, subsection 2 provides that before preparing guidance under this section, the relevant CMO must consult such persons as they consider appropriate. Amendment 395 adds a duty for the CMO to consult persons with learning disabilities before preparing such guidance. This may call into question why other specific groups are not expressly listed. In addition, Amendment 396 would add persons with learning disabilities as an additional category of people that the CMOs must have regard to in relation to the need to provide practical and accessible information, advice and guidance when preparing guidance under clause 31. The effect would be to include persons with learning disabilities as a specific category of people in addition to the listed categories. This could imply that those with learning disabilities would not already be included in one of the categories already listed, namely persons requesting or considering requesting assistance to end their own lives, the next of kin and families of such persons, and the general public. Chair, clause 31 stand part sets out a duty on the Chief Medical Officers for England and Wales to publish public-facing guidance relating to the operation of the Act. It has rightly been a matter for this committee to determine amendments to the clause, and the Government will respect the will of Parliament. As you will know, the Government has been working with the bill sponsor on amendments throughout the bill to ensure that, if passed, the legislation will be legally robust and workable. On this clause, we intend to support the development of further such technical amendments at report stage. Where amendments are required to clarify the obligations in relation to the preparation of guidance, we will work with the sponsor to ensure that MPs receive good notice of these to give adequate time for consideration. I hope those observations were helpful to the committee chair.
Kim Ledbetter.
Thank you, Chair. I'll just briefly show my support for these amendments in the Honourable Member for Bexley and Crayford's name.
Daniel Francis.
I beg to move the amendments in my name, Chair.
Amendment 395 to clause 31, as on the amendment paper, the question is that the amendment be made. As many of that opinion say aye. Aye. To the contrary, no. I think the ayes have it. We now come to amendment 396 to clause 31, which has already been debated with amendment 395. Daniel Francis, do you wish to move?
Thanks very much, Chair.
Amendment 396 to clause 31, as on the amendment paper. The question is that the amendment be made. As many of that opinion say aye. Aye. On the contrary, no. I think the ayes have it. We now come to the question that clause 31, as amended, stand part. The question is that clause 31 stand part of the bill. As many of that opinion say aye. Aye. To the contrary, no. I think the ayes have it. Bambos Lambos.
I beg to move that further consideration of this bill be now adjourned.
The question is that further consideration of the bill be now adjourned. As many of that opinion say aye. Aye. On the contrary, no. I think the